J-Bone Nation, shaming of Jay. He's not a dopey dumb bitch. He gets laid. The court jester, the court DJ. It's time to dive into the case. To the case. Good morning.
Good morning.
Welcome to Defense Diaries and the Shaming of Jay. J-Bone Nation, what is up, brother?
Not much. How are you?
Are you surviving? As you guys know or may not know, Jay and Shan's and the kid, the air's been down. The AC, the central air, has been down in his house for now going on day 4. Is that correct?
Yeah, yesterday was rough. For those who were watching the stream yesterday, I had to get my little like ShamWow rag and just wiping the sweat off. But luckily, it looks like some rain is coming in, and tomorrow it'll start. Today is going to be hot. The afternoon is the worst, but it looks like tomorrow it will hopefully be a little bit better. In this,
dude, I just can't with the air going out. It's like I'm such a prima donna that if my air goes out, it's like, all right, let's go. I'm going to the hotel. Yeah, I'm not gonna like. There's nothing worse than trying to sleep in a hot room. Because I'm like, I can't sleep without a blanket or at the very least a sheet on top of me. It's like, can't do it. Like I need something on top of me. So when you have that situation where it's hot as balls in the house and you need some kind of covering and, you know, you've got like a fan going to try to, you know, like an oscillator, you know, and you're waiting for that 7 seconds for it to come back to you because you're trying to cool off, you know, your lady, and you know, it's like, it's dude, brutal. I'm sorry.
Yeah, and for folks who don't know, this is the second time this happened, and the guy came like, I don't know, a few weeks ago, and he like put coolant in, and he's like, listen, this is old, and it's like gonna be replaced. I'm like, how much does that cost? He's like, $14,000. I'm like, all right, so now it happened again. I'm like, first of all, I'm not calling him back here just to like, and then second of all, I can't afford that, so I'm just hoping. You know, it's August now. Get through it. Hopefully, the heat is done, and just do the best that we can.
Yeah, dude. Well, I'm sorry you're going through that.
Thank you. It's okay.
That is a very, very expensive fix. We had to do it like 3 years ago, and I have like a cousin that's an HVAC guy, and it still ran me like $7,000. You know, so it's like 14 seems outrageous to me. You better shop around, bro.
I'll definitely when it's time. We'll definitely look. But I guess for folks who are coming in, let's talk about what we're gonna do here. Yesterday, we kind of piecemeal watched SarahBoone. She had a hearing yesterday, but Court TV didn't release it, and I was watching it, and they had commercials. It was a pain in the ass. They have put the whole thing on their YouTube channel, so you can watch it straight through. For folks who don't know SarahBoone, she zipped her boyfriend in a suitcase and killed him. She has gone through not 1, not 2, 8 lawyers until the judge finally said, you're pro se now. Now, the interesting thing about this is she's nutty. She is absolutely like just a nut bar. You'll see in this hearing. But I'm so glad that Bob can watch this with us because I feel like, because now she's pro se and there's some issues with like getting her. She wants the evidence. She wants to like, maybe I'm crazy, but I have seen some other lawyers say this, like she may be creating some appealable issues here. So I think this hearing when Bob watches it, he'll be able to kind of comment on it and see.
Yeah, for sure. And I thought what would kind of be cool before we jump into the hearings, which do you have that pulled up?
No, I don't. If
you go, it's pulled up either way. But I thought what would be cool, just because I know when I tweeted it this morning, there were a few people that were saying I know nothing about this case. I thought it'd be kind of cool to watch maybe like 15, 20, 25 minutes of the interrogation. I timestamped the area right where, so the way it goes down, Sarah and her then boyfriend, George, allegedly are having a nice Sunday afternoon in what has been a combative relationship. Like he has been charged with domestic a couple times. I think she got arrested on domestic once. He was going through the process of, like in Illinois, and it sounds like they have the same thing down in Florida, where you can kind of get a free bite at the apple, meaning that if you go through the program, it's a diversion program, you can avoid the conviction. It's usually only available to somebody on their first domestic, and it typically includes having to go to counseling, anger management, some DV training, so they understand, what you're doing, and having a broader understanding of what domestic violence is. And if you finish all that successfully, then the state here in Illinois will drop the charges. So he was on probation. He had a probation officer. Like I said, they were a physical couple. There's no question about that. He had done some time in prison and or jail. I'm not sure which. And so on this Sunday afternoon, and they both drink. How much Sarah drinks it's one of the things that'll be queued up for us when we're looking at the interrogation. So on Sunday, they're out at beautiful day, said they were having a great day. It was a good day, like probably the best day in the past month or so. And they're hanging out. She had bought, I think she said she bought bubbles and paint. So they were going to, play with bubbles, and they were painting. And then at some point in the evening, they pivot and they decide to play hide and go seek. And it's a hide and go seek game that goes terribly, terribly wrong, as George somehow gets all the way zipped up into a large piece of luggage, at which point Sarah finds him. Found you. Oh, you're in the luggage. And he starts telling Sarah, I can't breathe. Sarah, I can't breathe. Can you unzip the thing? And she has a rather unusual response in terms of somebody playing a game of hide and go seek, which that's kind of where I went. I skipped through. We're going to skip through about the first half an hour of the interrogation. We're going to get to, and Sarah turned her phone over. Like they didn't have to. So on Monday she comes in. So Sunday, and she goes upstairs, leaves him down there, thinking that her story is she thinks that he's going to be able to get out, that he's the boy crying wolf, that he's going to be able to just take his finger and unzip the thing and he'll get out. And so she goes upstairs and claims that she just lays down and then passes out or falls asleep. On Monday, they have her in. So she discovers him Monday morning. She claims that it was the most horrific thing that she's ever experienced. 911 gets called. They come over there, a whole thing. They bring her in to talk to her Monday. So what we're going to be watching is when they bring her back in. And on Monday, she turns over her phone to them and her laptop. And she's like, oh, there's tons of video in there of like I started taping or videotaping when we would have blow-ups, and how violent he could get and blah, 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 blah. And so at the beginning of this interrogation, which we're going to skip, she says something to the effect of, well, you have my phone. Like, I want you to go through all the videos. And apparently she forgets that she had taken these two other videos.
Awful.
So that's kind of the case in a nutshell. And as Jay said, she has burned through many, many lawyers, like 8 lawyers. And what happened is finally the judge is like, you know what? I'm done. I'm done with you. I'm done with you in this lawyer thing. Like, you, for whatever reason, you cannot maintain a working relationship with any lawyer that you've had. So you're going to represent yourself pro se. We gave it the old college try to the tune of 8 lawyers. And now you're on your own. So I think that this little video gives you a pretty good idea of who she is, because she's no fool, I mean, she's definitely not like a stupid person. She's got some smarts, but when she gets caught up in this interrogation, it gets to the point where she's kind of out, like she's taken by surprise by the fact that she clearly completely forgot that she took these 2 videos.
Yeah, otherwise she would be given over her phone.
Right.
They're bad.
If you warrant, they still would have found him though. That's the thing. They still would have found him. But all right, so let's get started with this, and we'll watch. And whenever you guys let us know in the chat if you've seen enough or if you want to watch a little more. I was watching it again as I was driving Allison to the airport this morning. I thought it was pretty interesting, and I think that you guys will think it's interesting too. So let me get this thing up over here. What else going on, Jay? Anything good?
No, just this hearing. After we watch this, after we watch the hearing, I think it's just going to be. Like I said, I'm not. You're the lawyer, but it just seems like she's, maybe purposely. Obviously, she's trying to delay shit. It seems like, and interestingly enough, you mentioned jail and prison. People, I always thought, like I had put on Twitter that like maybe she's delaying this because she's in jail. She doesn't go to prison. But people coming at me on Twitter that. Prison is better than jail. I've never been in either, but I never heard that before.
Yeah, no, that's a thing. That's a thing. I think the difference between prisons and jails is once you're in prison, it's far more regimented. There's an aspect of jail where it's pretrial detainees coming and going. It's just a different thing in terms, especially if you're going in for a long stretch. It's like kind of getting to know people, where it's as crazy as it sounds, there's a little more stability in prison, just in terms of relationships and everything else with the guards, with other inmates, with programs are better. They have more going on there. So yeah, typically prison is often viewed more favorably than jail. Like Allison's going to plead a client out in Florida tomorrow, and he's been in federal holding for about 5 months now, and he is dying to get to prison. So it's just it's different. It's different. All right, so let's start. Like I said, this is about 30 minutes in. They've brought her back in on the following day. So this is Tuesday. And now obviously they have viewed this video. All right. And again, she's spoken about her phone, talked about the video. She's like, just watch it. You'll see. I mean, he was an abusive guy. So this is the exact moment in time where the worm turns right here.
No videos on Sunday. Not that I'm aware of. Okay. I mean, I get my phone. I maybe took a picture of them, the two of Tess and the dogs, and George and them dancing. But I mean, it's just Tess.
Mm-hmm. Okay. So I have something that I want to show you that we found, and it was from your phone.
Mm-hmm. All right. So if you didn't catch that right at the beginning, the cop is reinforcing the fact that she has stated that she didn't take any videos on Sunday, which is the date of the occurrence. And Sarah leans in. She's like, yeah, no, I didn't take any videos. So she's about to show her something.
Can you see it?
If you need to move it around, go ahead.
No, I don't remember that.
For everything you've done to me. For everything you've done to me.
Your battery's about to die.
Shut it down.
Oh, okay.
Let me.
What do you got that guy's future shirt there? Detective in that.
The battery doesn't last.
I like it. I like it.
It used to last a lot longer than that. I don't know what happened.
Okay. Let me just grab something.
All right. No, I was just simply asking because you had a look on your face when she asked you if you've ever done that before. You looked kind of shocked. And
No.
okay, but why did you say it like that? Like,
I don't think you all understand who I am.
okay. Well, tell me.
I mean, I've always been a straight-A student. I am an outstanding mother to my son.
Okay.
I excel at everything.
Everything, Jay.
What a
I would
bold
not do
statement to
that.
make.
You wouldn't lock somebody in a suitcase?
Well, I didn't completely lock it. I mean, I opened it with one finger. I left enough in there for him to get out.
Okay.
And I wasn't planning on going upstairs and going to sleep.
Okay. No, it was just the way you said it.
You guys
were
are scaring me.
Why?
Well, we just want you to watch this. This came from your phone. Don't you want to know what's on it?
Yes, please. Is it long? Because I don't know how much I can take.
Mm-mm.
She is something else.
I don't know how much I can take.
I don't know how to find her.
Yeah, good call, Sarah. She does have a Toni Collette vibe, this female detective.
Do I have to watch this? I continuously throw up. I don't sleep. I don't want to see it, if that's okay.
Well, it's on your phone, and you can either explain it or we take it for what it is.
Yeah. We're just trying to give you the opportunity to tell us what's going on. That's it.
Hey, Patty.
It's that long?
2 minutes.
No.
For everything you've done to me. For everything you've done to me. Fuck you.
And
Fuck you.
that's you, your voice.
Stupid. That's my name. Don't wear it up. Yeah, that's when you do and you choke me.
I don't want to watch it, please. Okay.
Last time we talked to you, you had said that you put him in the suitcase, he had 2 fingers hanging out. And you
I
went to
flipped him
bed.
over. I flipped him over, and that's where it was.
And there's 2 different videos and a still picture where, yeah, it shows you flipping him in different positions and him saying that he can't breathe and you saying, fuck
So
you.
this is upside down. So in order for him to have gotten into it,
It was flipped up.
All right, so here's what we're gonna do real quick. Now I'm gonna switch us. Let's watch the actual video so y'all have a frame of reference of what they're gonna be talking about. This video, if you've not seen it. What do you think of this video, Jay?
It's bad, guys.
It's bad.
It's really
Trigger.
bad.
I mean,
it's a trigger
the
warning.
concept of it is bad. I mean, the video itself is pretty much just a dude zipped up in luggage and her talking shit, but it's pretty brutal. Okay.
Sarah.
For everything you've done to me.
Sarah.
You can
For
hear-
everything you've
you
done
can
to
hear
me.
she's intoxicated.
Sarah.
Oh yeah.
Fuck you.
Sarah.
Fuck you.
Sarah.
Stupid.
Sarah.
That's my name. Don't wear it up.
Sarah. I can't fucking breathe, babe. Seriously.
Yeah, that's when you do and you choke me.
Sarah. 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 Sarah, I can't breathe, babe.
That's on you.
Sarah, I can't breathe.
It's on you.
Sarah.
Real or ransom. Might want to get video for it extra. Because I got this.
Sarah.
Real or ransom.
Sarah. Sarah, I can't breathe, babe.
Oh. That's what I feel like when you ching on me.
Sarah. I
Fuck
can't
you.
fucking breathe, Sarah.
Yeah. You should probably shut the fuck up.
Sarah.
Shh.
All right, so that was 2 minutes. There's another video. See, when you look at the beginning of this video, so this is the second video that's 22 seconds long. Recall where it was in the first video. The bag was over upside down, meaning the flap that you open your luggage and pack in and then zip it was face down on the ground. So now the second video, the flip-flop is moved. It was on this rug in the beginning. Now the flip-flop's over there, and she's clearly flipped the bag over. All right, so this is the second video, and it's only 22 seconds long. And it's approximately, I think, 22 minutes later. So, all right. So those are the videos that she's being confronted with right now. And she's a very, like, I think I'd describe her as cocksure. You know, she comes off as very, like, she's very, like I said, though, she's not an idiot. Like, she's definitely not an idiot, but she
was so fucking wasted that she didn't even know she had these videos and pictures on her phone when she
it's crazy.
volunteered them over.
Completely denying her intoxication. Like you'll see.
This is upside down.
Guys, this is killing me right now.
So this image is upside down, and then this small video that occurred 11 minutes later, it's flipped over the other way, closer to your dining room table.
Okay.
Now he's obviously still in there. So he didn't, how did it go from the back to the front?
I flipped it.
Okay.
My plan was not to go upstairs and go to sleep,
Well, that's what you did.
Yeah.
but not intentional.
No, you told me you went upstairs because
What?
you were
Stop
getting
here.
ready for bed.
Stopped here.
Okay, but
Where's here?
show me where you can see any fingers coming out, because there's the end.
It's, and his head's right here.
Mm-hmm.
So going like this, rather than going all the way up, it's like this.
But why is he saying I can't breathe, and why is he pushing on it as if he can't get out?
And it doesn't show a hole.
There's no
gap.
hole. There's no fingers. I don't see his fingers. There's no hole.
I don't know what you want me to tell you. Like, I don't know, like, what you want me to tell you.
I'm just showing you. I'm just telling you what we see and what we've heard from the
I
other video.
understand. I understand.
He's begging for you to let him out. You're laughing in the beginning, and then in the end, it sounds kind of like a.
No, it's not malicious.
Well, saying fuck you,
It's not malicious.
then what is that?
What does fuck you mean to you?
Well,
Like if I were to tell my
like he
partner.
does. Like, I get told everything but a white woman. So
Okay.
my intention was not to leave him in there. Please understand that. My intention was not to leave him in there.
But you went upstairs thinking that he could get himself
Yes.
out, but the video shows
That's
at
what I
no
told
point
you.
can I see his fingers. And
He'll
it
be up
looks
here any
like-
minute.
And then 30 minutes later, he didn't show.
And he's telling you
And I
he
didn't
can't
wake
breathe.
up.
Do you
He's
think
not
he's
able to get out.
joking? You told me he was laughing, and
We were
the
before.
video, there's no
When we
laughing.
first got in there, both of us were.
So how long was he in there for? Like, this video is at 11:12 when it starts, so was he in there for like a long time prior to you
No.
recording this?
No.
So it goes from funny to no longer funny,
But
and
I
you're
didn't,
the only one laughing.
but I didn't think that he was, like, panicky. Like,
So pushing up on a suitcase saying, Sarah, 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 I can't breathe.
George has done that in the past before too, where it's just like he thinks that he's woe is me kind of thing, where it's like I don't.
He's never been locked in a suitcase. That's why he couldn't get out. So
it's kind of. I thought it was
and
the
you
boy
know the oxygen
crying wolf kind of thing.
Okay.
And again, my plan.
But nowhere in there is he laughing. Is he joking? He is begging. And you're the only one laughing.
Okay.
And you're the only one saying derogatory comments, like you're mad.
No. Please don't, I don't mean to sound negative, and I don't know if I can say this, but like, it's like you guys are kind of trying to like feed me. Like,
no, I'm just trying to show you a video that you no longer want to watch because you probably don't want to know the outcome of how and what you said.
Well, I know what.
You know what's on that video now?
No.
You remember making that video?
Oh.
Why don't you remember making the video?
Probably because we had been drinking.
But you weren't drunk.
No. Just because I went upstairs and just because you're drunk doesn't mean that you.
Times that you were not drunk. You said that you had your wits about you. You said he had his wits about you.
Mm-hmm.
You said that you don't like not having your wits. In my experience, if somebody cannot remember doing something to the extent of making 2 videos and a video and taking a photo, they are intoxicated.
Okay. I understand where you all are coming from.
Well, we're just trying to make sense of it. We're trying to figure out what you're saying.
We're trying to figure out this video.
You explain it to us. We're listening.
I just did. Like, we were playing, and then, like, I thought it was, my plan was not to go upstairs and go to sleep. My plan was not to, he'll be up here any minute.
But you willingly went upstairs and went to sleep. No one forced you to go upstairs and get
My
ready
plan
for
wasn't
bed.
also to leave him in the suitcase.
So why didn't you take him out?
Because I went upstairs, and then I fell asleep.
But why didn't you consciously think, he's asking to come out, he can't
I didn't do it
breathe.
intentionally.
What do you think is going to happen if you leave somebody in a confined space like that?
Well, I thought by not giving it up all the way, it would be okay. My plan was not to leave him in the
And what was
suitcase.
your plan?
Waiting for him to come upstairs.
And then when he did it?
I fell asleep.
You said you were up there 30 minutes. After 30 minutes, somebody not coming up.
Knowing that that the last time you saw him was in the suitcase, 30 minutes later, you're like, maybe I should go check on him, maybe I shouldn't.
No.
Well, that didn't cross your mind because
that's like an assumption. Like, that's what you all are thinking. Just.
We're asking.
It's the whole.
You tell us.
It's the drinking. That's what it is. It's the drinking. I thought it was like, I thought he was okay. Like, I didn't,
He's telling you he's not. He's telling you, Sarah, I can't breathe. He's saying your name and you're like, that's my name, don't wear it out.
Guys, that's how we are with each other. Like, nobody understands our relationship. The whole suitcase thing never happened before.
Would you leave someone else in a suitcase? Would you leave Lucas in a suitcase jokingly? Because it was a joking matter. You put him in there jokingly. Would you leave Lucas jokingly in there? And you love Lucas, right? And you
I
love
wouldn't do
George.
that to him either. I wouldn't do that to him.
So I just.
Well, it's not like, again, I don't think you all understand. Like,
we understand.
I mean,
it's not that was not my intention. Y'all don't have any idea what I've done for him.
But by your acts, and that's exactly right. You get to the point where you've done so much for somebody and they don't show you any appreciation.
He did.
Not by your words in the video. I don't get that.
He did.
Because you bring up the fact that when he's choking you, you can't breathe. That's how you felt when he cheated on you. You couldn't breathe. And you verbally several times told him just fuck you.
Well, you said it in the video, but you won't let us play the rest of it. You don't want to.
When I say cheating, it's on his phone.
Okay. Cheating is cheating.
I think so too.
Exactly.
It's your definition of cheating, though. So, I mean, that's what the word cheat means.
And that's what you told him in the video. That I couldn't breathe when you cheated on me.
No.
That's how I felt when he said, Sarah, I can't breathe. And you told him,
I don't know what this is.
What would you say if somebody told you that they had done this?
Done what?
Zip somebody in a suitcase and went up and went
On
to bed.
what?
Do you all not think,
On what?
so you
What?
all think that it's like, oh, good, I got him in there, now I'm gonna go to sleep? Is that what you guys are trying to assume? Or trying to like,
We're just, the video is very portraying of the opposite of what you told us.
no?
It is not leading up, it is not matching what statement you gave us in the car.
So,
And that's why we want to know,
and
the
I don't remember
injuries-
doing those.
the injuries are not consistent with what you told us. So we have a lot of inconsistencies, and this video explains itself. It really, truly does.
You don't think that I have thought about that?
Thought about
No,
the
you didn't know
video,
the video
or thought
existed.
about?
But no, again, if you don't mind, please.
No,
So
I don't
you
think you thought
all
about it. I think
are
you told me
assuming
about
that
it.
it's like, oh, good, I got him in there, now I'm gonna go to sleep? Is that what you all are assuming?
Well, it's not an assumption when that's what you told us, so that happened.
That's what
Mhm.
happened.
And the video,
Oh man.
Yeah.
yeah,
Not
I mean,
intentionally though. Not intentionally.
I'm not gonna say,
you thought he could
Those
get out
are-
on his
yes.
own. But the video shows that he cannot get out on his own.
but when I unzipped it with one finger,
From the outside.
but it had the hole in it.
And you're claiming that it had a paper clip, so that's what assisted you in doing it.
No.
Is what you told us.
When I had my sweatshirt, I said I thought it had a paper clip on it. It's
But
got,
the zipper part is broken, that
yes, which is why we were gonna
Helps you
send it.
Yeah.
I just,
You were able to unzip it from the outside very easily, because that's the way they're designed.
but you could on the inside too. I don't know how.
Well, why wouldn't he have gotten himself out if he could? He was
I don't
asking-
know,
he was
like, I don't know if
asking.
you saw, like, where the hole was. I don't
I
know.
didn't see a hole.
No
I
one
didn't
sees
see
the
no
hole.
fingers
You're the
sticking
only
out.
one that's what I'm saying. Like, he's in one position, and where his head would be, we should be able to see fingers. And then when it's flipped over onto this right side, again, his head is closer to us facing the video, so we should be able to see fingers, and we don't see anything. We see no movement of him trying to unzip it or physically unzipping it. All we see is pushing up, trying to push out of it.
Please do not assume.
I'm not
My-
assuming.
my
I haven't
intention-
assumed anything. I follow evidence.
But my intention was not, again, oh, good, I got him in there, now I'm just gonna go to sleep.
What do you think someone that knows nothing about this or hears just a little bit like, oh, they were playing around in a suitcase
She's been
and then
drinking,
and then
and
watches that
probably went
video?
to sleep. That's what happened.
But you let him out before. I mean, you put him in, so why didn't you take him out?
Because I was upstairs and I fell asleep.
No, before you went upstairs. You like consciously had to walk upstairs. I mean, you obviously remember going to bed because you were able to give me a time frame on that. And you specifically
Mhm.
told me that you
I
went
don't-
upstairs.
My intention is not for this to happen. I am sick about it. I've never done anything like this before in the past. I am sick. Especially with that. I thought I couldn't sleep last night. I don't know.
Well, here's the thing. You tell us the last night, you vividly remember this when you told us last night, that he was laughing, you were laughing, you put him in the suitcase, he has two fingers sticking out, and you go to bed. Now we see something totally different, and it actually shows you upset, and again, using derogatory terms to him when he's begging for his life to get out of that suitcase.
So,
So
But
what
my thing
you
is
say
that
we're
the-
assuming, we're not assuming,
but
we're
the
telling you
finger,
what's on there.
but, so it just happened to be that whenever I was videotaping or doing whatever else it was, just happened to not have that in it.
Okay. And you also, in the video, you can't see any holes. There's nowhere in that where the zipper separates and you can see a hole. If there's a hole, he's pushing on it, begging you to get out. We should probably see that hole that
He
you're
eventually
talking
would have
about.
been able to get out. Based
Alcohol,
off what you're telling us, he should have been
Yes.
able to get out.
Okay.
But the video shows him attempting to get out, begging to get out, and he can't. So that's just what we're trying to figure out. I don't know if maybe you had too much to drink, you zipped it up all the way, and then,
I did not zip it up all the way.
Okay, well,
I did not zip it up all the way. This is horrific, okay? Horrific.
it is terrible.
Yeah, so they-
Horrific. I don't think I'll ever be right because of this. ever be right. Dealing with everything else that I have in my life, personally, and then this,
Okay.
whom I loved, it was not intentional. I will put my hand on the Bible. It was not intentional. I would not do that to him nor anyone else.
But you did.
Not intentional.
You intentionally went up to bed.
I didn't intentionally
left
go to
him.
bed because I'm thinking, okay,
Hold
good,
on,
he can
hold
get
on.
out.
How did you not intentionally go to bed? You said you went upstairs and got into bed. That's intentionally going to bed.
Waiting for him.
And he doesn't come, but you don't go down to check on him.
So I happen to go to sleep. When I say go to sleep,
And what do
it
you
goes
normally do
off
when you
whatever
go to
you're gonna
bed?
do.
What do you normally do when you go to
Hi,
bed?
Grandma Kathy. And
What
Kenny.
is the bed for? Going to sleep.
Right.
So you go to
But
bed to
obviously
do
you can
what?
tell too that, like, I've
You
been
go to
drinking
bed to do
also.
what? Okay. You kept telling us, hey, I wasn't intoxicated. I wasn't this. I wasn't that.
Being drunk and intoxicated, which, yes,
Okay.
you can tell that I had been drinking, but
Okay. So if you weren't intoxicated, then why would you ever leave somebody in a suitcase that's begging to get out, that's telling you they can't breathe?
if I hadn't been drinking, you still think it would be the same thing? Where it's like, hop in, I'm gonna go to sleep. Is that what you all are trying to do? To portray me
We're not trying
as?
to do anything. I'm simply asking you to explain to me what happened.
Everything was fine and dandy.
I don't want to call
Everything
it fine and dandy.
was fine and dandy.
Explain
You
to
all
me how.
don't, okay, for me to tell you this, again, mind you, I've been without him for a day now.
Mhm.
I don't know, I mean, I don't know what you all want me to tell you, because this was not in any way, shape, or form, hand on the Bible, intentional.
Okay. So you just left
I
him there to
didn't
teach
kill
him?
him.
You left him there to teach him a lesson?
I didn't mean to leave him there. That's what I'm trying to tell you.
You got up and walked away. How is that not intentionally leaving him there?
Because I'm looking at the hole, knowing that it's there. He'll get out no problem. Because you
And
don't,
then he doesn't, but you don't go check on him. You say you're up for 30 minutes and he doesn't come up. You don't go down and check on him?
I'm in the bed.
You even moved,
And dozed off.
you admit to moving the suitcase, like, over,
You
so
roll it.
you roll it out, like, it's not like,
I didn't want it to be like that. Don't,
you didn't want him to be upside down. How do you even get upside down?
right. You guys are killing me right now.
I just want you to hear it.
Ouch.
That's how he talks to me most of the time. I don't know how you want me to say it.
I'm just trying to figure out what you would expect to happen to somebody when you leave them in a suitcase.
I didn't mean to leave him in there.
Okay.
What's your reasoning for, not calling 911 sooner?
Because I didn't know what to do and how horrific it was. I called Brian, and like what, 5 minutes later I called you guys? Not even 5 minutes. Nonetheless, that I had to I was trying to do CPR. I had to get him out and try to do CPR, and then called you guys. And then was continually doing CPR with the dispatch on the phone, where he had me count out loud to help me focus on what I was doing.
It just, I don't know how, I mean, you can sit here all day long and say, I thought he was gonna get himself out, but that he didn't, and you went upstairs, and you stayed there for 30 minutes before you fell asleep.
But can I say too, like,
You chose not to ever at any point during that 30 minutes walk back down and check on him.
no, wait 1 second, because I know, like, with you all, and then, like, because you continually ask me, like, time frames, where I told you, like, I don't bother even looking at the clock most of the time. So it's like a guesstimate. So for all I know, maybe it was 10 minutes.
Okay. But the point is, you left the living room where he was begging for help and went upstairs. Regardless of how long you were there, you left. You say,
I thought he was the boy calling wolf. Again.
Okay.
So when he asked to be let out, like, what's your reasoning for not letting him out?
When I was upstairs?
No, when he's asking on the video, he asked multiple times. He asked to be let out. I can't breathe. Why didn't you let him out?
Well, number one, I had no idea it was going to end like that.
Okay.
Number one.
Okay.
Number two, just, you know what? I'll give you 5 minutes or so in there. They'll give you 5 minutes or so.
5 minutes for what?
Well, based off the video, one video is at 11:12 and the next one's at 11:23. So you actually gave him at least 11 minutes per video recording. So my thing is, when it stopped, he asked multiple times. I mean, why? Why did you not let him out? It's just a simple question.
To be honest with you, I mean,
Don't
Were you
know.
punishing him?
no, just,
Well, that's what you're saying in the video.
This is what you get. This is
Yep.
what you make me feel like.
see, and then it's all backfired on me. Like, it's all backfired on me. And I understand the severity of this.
He's dead.
It's awful, I know.
Okay.
It's awful. And I will tell you both this right now, too. I will never drink alcohol again.
Okay.
Like, I will never drink alcohol again. I don't care what it is in any way, shape, or form.
But let's get back to this. What was the reason for leaving him when he's begging to be let out? I don't understand that.
What I have a feeling was, and again, it's the whole time frame thing. You all keep asking.
I'm not asking you a time frame. I don't care about a time frame. He's
So-
in the bag saying, I can't.
My God.
And you say, fuck you.
For the whole few minutes that he was in there,
Minimum 11. But yes, go ahead. It's a few. 11. Minimum.
For the one video.
Well, in between the two videos. It's
Between the
11
two
minutes.
videos? Okay.
Yeah.
so what's the question again?
When he's begging for his life, telling you he can't breathe, let me out, and you say, fuck you, why don't you just let him out? What are you trying to prove to him? There was obviously something in your head that you were thinking of when he was asking to be let out, and you're like, no,
Again, it's the
no.
boy.
All right, so do we have enough of a flavor? Do you guys kind of you get what we're dealing with SarahBoone, and she is no different in court. She's just as combative. She's got that smartest person in the room vibe always. She's gone through 8 lawyers. No lawyer can work with her. You know, I've had clients like that where, you know, they are the smartest person in the room. There's no telling them shit, even when it's not in their best interest. And that's where it creates an issue with lawyers. You know, if I know something to be in my client's best interest and they're just absolutely defiantly refusing to take that advice, you know, that's the point where we start having the conversation. Well, we're at an impasse. You know, like I can't go in and represent you this way because it's not in your best interest. I'm not going to do it. And that's on repeat what's going on with her. So leading into yesterday's hearing, essentially, as Jay told you, the last time she was in, the judge said, "You're done. I'm done assigning lawyers to you. That's over. Now you're going to represent yourself." And it gets interesting. Constitutionally speaking, it's going to be interesting to those people out there that are saying she's setting up her appellate issues. There's no question about that.
Yeah, in the last conference too, she was making issue of she wants like discovery, she wants all the records, and they're like, well, we'll give you a thumb drive with a computer that you can use. She's like, well, I want paper, I want the files, because if I'm up at 2 a.m, I want to be able to look at it. So like that was an issue that came up last time, which I think they also discussed in this hearing that we had one yesterday.
All right, so chat, you good with the amount of? There's probably like another hour of this interrogation left.
And it's just basically this. It's just like
Same
circling
shit,
in
right.
circles.
There is no answer to this. There is no answer to this from Sarah's perspective. Like, she's never going to come up with a good answer at any point during this entire, I mean, she went upstairs. She had him zipped in there. She went upstairs, passed out, probably more likely than not. I mean, when I first heard about this case, my first instinct was like, it seems like you'd be able to breathe through like a cloth suitcase. Like I didn't realize, obviously there's not going to be nearly as much oxygen making its way into the suitcase, but I didn't think it would be to the level where somebody would suffocate. But clearly I was wrong, All right, so I'm going to pull this guy down, and I got the other dude queued up. Let's go to that.
So this same person who we just watched is like Bob said, she's exactly the same in court, and she's going to be exactly the same as her pro se attorney if that's how this continues to go, which it appears. So if you guys know Darrell Brooks, this is going to be on that level. And it's going to be streaming. I mean, it's Florida. This is going to be a trial in October if they don't push it back, which I don't know if they will, but I think I forget what date in October, but it's coming up. By the way, folks, we didn't say this is 4 years ago that this happened.
Yep. 2020, February 2020. All right, let's see here. All right, so let's peep it. All right.
Date of birth for the record for me.
SarahBoone, 10777.
I do see that we have a representative from JACS that's appearing virtually. Sir, can I get you appearance for the record as well?
We have to boost some volume.
Yes, Your Honor. Christian Lake with the Justice Administrative Commission.
Okay, very good. All right, we've got a couple of things that we're going to be addressing this morning. The first is the motions, Ms. Boone, that you had made reference the last time I saw you. The court has reviewed all of those motions. I've reviewed also JACS's reply, specifically their response to the motion seeking due process costs that was filed on July 30, 2024. State, have you had the opportunity to review all of Ms. Boone's motions?
Yes, Your Honor.
Okay, all right. Ma'am, I want to go through each one of them and hear from the state, from yourself, and from JACS. We're going to start first with y'all can be seated, you don't need to stand, thank you. The defendant's temporary motion for reservation of proposed costs to acquire investigator for defendant's defense and trial dated July 18, 2024, received July 29th. That request seeks to reserve any and all costs proposed to be incurred to acquire investigator. The defendant's temporary motion for reservation of proposed costs to acquire all witnesses for defendant's defense and trial dated July 18, 24, received July 29th, 2024. The request is to reserve any and all costs proposed to be incurred to acquire all witnesses for trial. And then defendant's temporary motion for depositions to be conducted per FRCP Rule 3.220 by defendant under pro se attorney title and position ordered by the judge in court dated July 18, 2024 and received July 29, 2024. I have reviewed all of those motions. All three motions reflect to be determined or TBD with regard to the investigator, witnesses, and deponents. The total amounts are to be determined. How to calculate is unknown. As to the depositions, the date are to be determined, and the amount of transcripts are unknown. Mr. Lake, I've reviewed your response. Do you have anything else to add, sir, with regard to those items, investigators, witnesses, or deponents?
Not really, Your Honor. The only thing is if we can provide Ms. Boone a copy of our pro se packet that has information about including model motions. We would be happy to send her a copy or to send your JA a copy that you could send to give to her. That might help her for purposes of future motions. But as far as these are concerned, I think our response pretty much outlines what our position was to each of those requests.
Okay, thank you, sir. If you would be so kind to send that to Ms. Barrios, we will ensure that Ms. Boone gets a copy of it. State, do you have any position with regard to those three motions that the court just identified?
No, Your Honor.
Okay. All right, ma'am. So previously, Prison Break Investigations was already appointed to be your investigator. The JAC has no objection to authorizing $5,000 in costs for prison break and for $500 for obtaining case-related documents and materials on your behalf. So seeing as there's no objection, even though you were asking for a reservation, I'm going to go ahead and permit that cost to be incurred. With regard to the costs for witnesses and the depositions, you are requesting, as I identified earlier, just to reserve those costs. And as I had said earlier, the motions do not identify who the witnesses are or what the deponents are. So I'm going to deny those motions with prejudice, but that means you can refile them and we can readdress them when you file motions in the future addressing any of those items for ensuring witnesses being subpoenaed or appearing for your defense at trial, or for any persons that you may seek to depose. Because as of right now, I don't know who it is that you were seeking to depose based on your own motions. Do you understand the court's ruling as to those three motions, and do you have any questions, or do you want to add anything?
I would like to add, please.
Sure.
With your delegated due date of July 22nd, for all of my pretrial motions to be submitted, I have yet to receive my discovery, so I was trying to beat that deadline or at least meet it. So I don't know what I'm supposed to ask for or who I'm supposed to ask for. And again, I have yet to receive my discovery, so I don't even know who it is I need. So I understand for those. So you're telling me at a later date, once I have that information, to revise them.
I'm giving you the opportunity to refile. Yes, ma'am.
Thank you.
With regard to the defendant's motion for reservation of proposed costs to With regard to defendant's motion for reservation of proposed costs to acquire expert witnesses for the defendant's defense and trial dated July 18th, 2024 and received July 29th, 2024. Mr. Lake, anything else to add other than what is identified in your response?
No, Your Honor. Again, the issue here is, with the exception of the mental health expert that's already been approved, there would need to be much more specific motions for these costs. Ms. Boone needs to include essentially what we included in our response. And again, the model motions that we will be sending to will have that information. Without specific information, neither us nor the court can make an informed decision on whether the requests are appropriate.
Okay. Ma'am, the motion fails to identify any specifics. It has to be determined for your expert witness or witnesses. It does not identify the type of the witnesses. It doesn't identify the amounts, and it's difficult for me to identify the particular showing of need, which is what's required for the appointment of that expert. So again, I'm going to give you the opportunity to refile in the future a motion pertaining to any specific experts, identifying the specificity that JACS has requested in their response. So at this point in time, that motion is denied without prejudice, and you'll have the opportunity to refile it. Lastly is the defendant's motion requesting immediate relief to the defendant by appointing effective standby counsel to aid in support and preparation of a criminal case for trial dated July 18, 2024 and received July 29th, 2024. The request, ma'am, that you were seeking in that motion is to provide immediate relief to defendant by appointing effective standby.
So just so you guys know, standby counsel, like typically what you'll see with the pro se defendant, that they will have an actual attorney kind of sitting behind them during the trial. Like if there's issues that pop up, that counsel will be able to kind of guide her, tell her rules of evidence, tell her what she's doing wrong in terms of trying to get evidence in, because that's one of the frustrating things for lawyers and judges when you have pro se defendants or pro se litigants in general, is that they just don't understand the rules of evidence. And the rules of evidence are strict and they're certain in terms of what's allowable and how you do things. It's like impeachment. There's a certain way that you impeach people. You have to do it properly. You can't just go out there willy-nilly. And the judges, while they will give pro se litigants some wiggle room, they still have to abide by the rules of evidence. So like you don't get to throw out all the rules just because you're a pro se defendant. You know, you have to follow the rules. And, you know, that's what makes this case fascinating is the concept that she's gone through so many lawyers, you know, and we don't know what they've been suggesting in terms of potential defenses. If we're to take what she was saying in her interrogation as that's still her mindset, which I have every belief that it is, that this was not intentional, that she didn't intend for him to die, that was not her intention. And just so you guys have a bit of a primer, she was charged with second-degree murder. And in Florida, that's defined as either the killing of a human being during the commission of a second-degree felony, or, and this is the one that applies here, or through an act that is imminently dangerous to human life, demonstrating a depraved mind. And then it says also if the defendant was involved in the commission of a predicate felony, but the homicide was perpetrated by another co-felon, the defendant can be charged with second-degree murder. That does not apply here. The penalties in Florida for second-degree murder, it's a minimum of 10 years in prison, probation, if a firearm is not used. We've heard no indication that a firearm was used. I don't think that she pulled a gun on him, or at least I haven't heard that she pulled a gun on him and said, "Get your ass in that suitcase, sucker. I'm going to zip you up." The minimum of, if she would have used a firearm, it would have been a minimum of 25 years, much like what happened with Benefield. Like, we know that the gun was used, so that kicked that manslaughter charge up to a much higher minimum because of the use of the firearm. For adults, the maximum is life without the possibility of parole. So that's what she's looking at.
And you know, Bob, before you start again, one thing that I noticed with this judge is that he's, and you could probably comment a little more on this, but he has to walk like a kind of like a fine line where he has to, like, he wants to tell her the decision, but he can't give her legal advice, because he says that sometimes, like, he cannot. Like Bob said, he's going to probably give some leniency because she's pro se. Really, and I saw this, I think it was Josh Schiffer or someone else was like, really, it's supposed to be, if you're pro se, there should be no help. You want to do this shit, but it never works out that way where there's always some leniency given because they kind of like, well, for whatever reason. But the judge, like, because she like goes back at him and she's expecting him to like kind of show the ropes, but he can't give legal advice. He can give his decision.
Cannot give legal advice, right?
So like he's kind of on that line where he's trying to tell her what the decision is without giving her like, oh, but you should be doing this. Like, he can't do that.
Right. Exactly. And I've never had to go against a pro se litigant in a criminal case because obviously I'm not a prosecutor, right? So I've always had, and I've never been assigned to be standby counsel either, like, which would be equally irritating. But I have in divorce cases gone against pro se litigants, and it's super irritating. It's super, like, for everybody involved, like for the lawyers involved and the judge, and like, you know, and I'm bitching about that. I'm like, he still has to follow the rules of evidence, Your Honor. Like you're giving him some leeway here, which, okay, fine, but he still has to follow the rules. This isn't a free for all. Like, you've got to follow the rules. And it's just, it's a tough situation because everybody's trying to get through the trial, and it's a much longer event because of the lack of understanding of the process. You know, it's just, it's frustrating. This
probably the most,
probably be 2 weeks longer.
Yeah. I'm probably, sorry.
Go ahead.
I was just gonna say, probably the most irritated person in that process in a divorce is your client, who's like, this fucking guy who I'm trying to get divorced with now. Like, and I'm sure they're probably like, he's doing this shit on purpose because, like, he knows, or he or she is, they're doing this on purpose because they know they're gonna make it more difficult because we just want to get to this divorce, and now he's gonna fucking represent him, you know, I'm sure, or him or her.
100. That's exactly the conversations that took place. Exactly. All right, so let's keep chugging.
By counsel to aid and support in preparation of her criminal case for trial. State, do you have any position with regard to Ms. Boone's request for standby counsel?
No, Your Honor, other than what's already been placed on the record in the court's order.
Anything over and above what's in your response?
Just briefly, Your Honor, the point we would make, Your Honor, is I think Ms. Boone misunderstands the role of standby counsel. Standby counsel is not co-counsel or assistant counsel to a defendant. Standby counsel is there for when, in the situation where a pro se defendant who is elected to represent herself decides at some point they want a lawyer, that allows the court to put a lawyer back into play at that point in time. In other words, it's a safety mechanism so that if a defendant who is asserted to represent themselves decides at some point they do no longer want to represent themselves, the court has a lawyer already in place so that the progress is not delayed. It is not an assistant or a co-counsel. It is someone whose role is consenting not to get involved until the defendant says, I no longer want to represent myself.
Ma'am, the courts had the opportunity to review the case law on this issue. There is no constitutional right to standby counsel as decided by Paul versus State, 152 Southern 3rd, 635 at pinpoint 641 by the Florida 4th District Court of Appeal in 2014, citing to the Florida Supreme Court case in Jones v. State, 449 Southern 2nd, 253 at pinpoint 258 from 1984. As the court has determined that you have forfeited and alternatively waived by your conduct the right to court-appointed counsel, the court is not required to appoint standby counsel. That's Brown v. State, 45 Southern 3rd, 110 at pinpoint 114 through 115. Florida 1st DCA 2010, citing to, again, Jones v. State by the Florida Supreme Court in 1984. There is no Sixth Amendment right to simultaneously proceeding pro se and with legal representation by the Florida Supreme Court in 2009 in Shepherd v. State, 17 Southern 3rd, 275 at 279. For the reasons that the court identified in its 16-page order previously entered, your request for standby counsel is denied.
Wow.
Do you have any other questions, ma'am, as to the court's rulings this morning?
First off, I do not forfeit my rights. That was your judgment. And also, I feel that I should have had some type of evidentiary hearing prior to your decision. So I could have better explained myself and you could have had a better understanding. So by you denying my standby counsel, which thank you to him for explaining to me what specifically it is, I don't want to be pro se any longer. So I didn't want to be pro se in the first place. And again, you, in my opinion, unlawfully denied me or didn't even suggest an evidentiary hearing in order for me to avoid or try to go about a solution or remedy to even understand. So I don't know if it's me either wasting your time or anybody else's time, if it's even an opportunity, or if it's just something that is denied, period.
It is denied, period. With regard to an evidentiary hearing, that seems to be in the realm of a Ferretta inquiry where a criminal defendant is seeking to represent themselves. And I would inquire of that person and have an evidentiary hearing as to the rights and remedies that you were forfeiting and the pros and cons of proceeding representing yourself and the benefits of being represented by counsel. Due to the Florida case law that was provided in the 16-page order, no such evidentiary hearing is required.
My understanding was the hearing, the Ferretta hearing, is regards to competency as opposed to having understanding before you take someone's right away.
Ferretta pertains to a criminal defendant's seeking to represent themselves. Ferretta was not applicable to your situation, and that's identified in the case law citations that were provided in the 16-page order.
Yes, I understand. It was the day of that I was explaining most of all of this, and as opposed to prior, so I would know what happened or could happen. So my understanding is one thing, and then the explanation is another. So I'm just confused and feel that I should have had an opportunity prior to all of this to explain myself and to have a better understanding. So now my belief was that the evidence or the Ferretta hearing was simply competency. So the evidentiary hearing I thought would be a collaboration of the information of why I wrote my letters in order for you to remove my right to counsel. That, in my opinion, I felt that it was a type of retaliation by the court because you did not understand or attempt to understand any of my letters that I wrote previously, which was for the intervention of the judge and or the court to avoid any of this with me sitting in front of you present.
Ma'am, as identified in my 16-page order, I listened to every audio hearing. I specifically provided dates and times and words that were specifically said at particular hearings involving yourself and prior counsel. I also made reference in the 16-page order to statements that were made in your letters. I promised you, I've read everything in the court file. I've read every single letter, and I've listened to every single audio. That decision was not made lightly, and it took a lot of time to make that determination and that decision, which explains why it was also a 16-page order. That order stands, it remains. The court's not going to revise its findings or its determination as to your forfeiture, and alternatively a waiver by virtue of the conduct identified in that order.
Okay, I believe, in my opinion, the order is erroneous, and after I reviewed your 16-page order, there are quite a few incorrect entries, and some of them are based on perjury by the attorneys. And by you reading and then also listening to the audio, you did not listen to me in any way, shape, or form in order for me to explain myself better, so you have an exact understanding of the particulars of each letter for each attorney.
I'm not going to revisit my prior decision.
I understand. I'm just trying to make you aware that is my opinion.
You, and like we talked about last time, ma'am, you're certainly entitled to that opinion. All right. My judicial assistant has been in contact with the representative from the Orange County Jail, Sergeant Donald Casey, who is on his way in order to facilitate the transfer of the USB drives from Prison Break Investigations. I do see that Mr. Lane is present. So as soon as he gets here, we'll be able to address that exchange. What we can do while we're waiting for that representative to appear is address some of the things that were identified in the notice of hearing for today, which is kind of a scheduling conference for when we might be setting up certain deadlines. As of right now, the trial is scheduled for October 7th. The trial will be extended from 2 weeks to 3 weeks. So the trial will take place on October 7th, October 14th, and the third week of October 21st. October 21st is not this division's normal trial week. However, the court has obtained coverage for that week so that should this trial proceed into a third week, we will not have to scramble in order to find coverage, and that we'll be able to efficiently proceed with any evidence or testimony on that third week on October 21. Pre-trial was scheduled for September 24th at 1:30. The court typically has its regular trial case managements on that Tuesday. Due to Ms. Boone representing herself and some of the complex issues that may be involved in this case, I'm inclined to change the date of the pretrial so that we might be able to have our own pretrial separate and apart from all the other cases that may be set for that same trial period. My thought would be to move it to, rather than the Tuesday the 24th, to Tuesday the 26th at 9 a.m.
Is that a Thursday?
Yes, sir. That's Thursday.
That's acceptable to the state.
Ms. Boone, that would give you additional opportunity to prepare for trial as well. Are you amenable to changing that date to September 26th at 9 a.m.?
So an additional 2 days?
Correct. You would still have that time to prepare regardless if we had the hearing on September 24 or September 26th. I'm just moving it so that we don't have 50 or 60 other cases and I can focus more attention on your case specifically.
Of course.
Okay, all right. So pretrial will be rescheduled till September 26th at 9 a.m. One of the issues that I wanted to address was deadlines for production of the state's exhibits and the defendant's exhibits. Now, I'm mindful, Ms. Boone, that you have not reviewed some of the documents that may have been provided. I know most recently, Ms. Cashman spent 20 hours with you alone going over questionings and reviewing some of the materials. I don't know the breadth and scope of what was reviewed to you, but some of it may have been reviewed to you based on counsel's representations. State, I want to address with you first, because Ms. Boone hasn't reviewed the discovery yet, as to what your position is with regard to assembling or finalizing an exhibit list or your exhibits for trial.
As far as providing a list of the specific items that the state seeks entry of?
Correct.
My man didn't take off his
I do want it before
raincoat
pre-trial.
there. He's
So let
got
me just
Debbie
kinda lay
coming
it
down
out
on
for
him.
What? I had the
this
volume booster up, so it really mutes you.
Oh, sorry. I was just saying this dude didn't take off his raincoat. He's got Hurricane Debbie in Florida. He's like, I'm not even taking off this raincoat for this hearing. I'm keeping this fucking thing.
Yeah. It I think it got downgraded to a tropical storm because
Is it?
Allie was flying into Miami, and
Shit.
I was originally going to go with her, and I opted out because I have a lot of shit to do. But yeah, but it sounds like she's up in the air, and it sounds like she's going to land because they were giving waivers and allowing people to change their tickets, and they were warning us that there was going to be potentially a lot of canceled flights and shits like that.
That's the worst.
It's the worst, man. All right, so let's keep going here. Yeah, it didn't even take off the old trench, huh?
Wow. The court's thinking. The court would have the state provide a exhibit list and a witness list by X date. Ms. Boone would have the opportunity to look at that list. We would then have a hearing where all of the exhibits would be shown to and provided to Ms. Boone. They would be provided on a USB thumb drive that could be utilized with a laptop at the jail. And then she could view all those exhibits here in open court. And then she would be afforded the opportunity to make an objections in writing to any exhibits at a later time by a certain date.
I guess one of the concerns would be that if the state identified specific items that we would seek entry of, depending on the course of the trial and the questioning, there may be other items that have already been disclosed in discovery that may necessitate being entered in, would potentially not be part of this original witness exhibit list. Items that were in the discovery, but if that makes sense.
That does make sense. Yeah. And I understand what you're saying. And that seems to be more of a fluid situation as to what may happen at trial, right?
Sure. I don't imagine the court's intent would be for the state to just produce the exact witness lists that have already been sent in discovery and just make a notation of every item of evidence. The idea would be to try to pare down.
That's exactly the idea. Yeah. Now, obviously, that wouldn't foreclose you if something was produced in discovery and something that would not be relevant or admissible at a certain stage of the trial, but maybe later became relevant or admissible due to something that happened or something that was said. I would not foreclose the state, nor would I foreclose Ms. Boone from attempting to move that piece of evidence into evidence for the jury to consider. But it would be almost like a civil conference where you and opposing counsel would go over what your exhibits are prior to proceeding to trial. And I think that's important to do that so that Ms. Boone has the opportunity to view those in court so that's on the record as to what she's reviewed, and then give her the opportunity to provide any objections, if any, to any of those exhibits. And again, I wouldn't foreclose you if you want to use items A, B, and C, and that's all you intend on using. I don't know what you intend on using. I don't know what evidence you have. If you only want to use and only show A, B, and C, but are saving D, E, and F for later, depending on what happens, I won't foreclose you from readdressing D, E, and F. But it's just an opportunity to address what it is you think you're going to be seeking into evidence at this time.
So essentially,
Mafia lawyer would like a word.
Go ahead, sir.
I know who framed it.
so I think we could accommodate that if we could go around September the 1st for that, and then that would give her an opportunity to review that USB and lodge any objections, and then we could potentially address those objections and go from there.
Okay. And that would be September 1 to have the evidence viewing, for lack of a better word, or for the list to be provided?
For the list in the USB.
Okay. We're going to make this work for an October 7th trial date, Judge. I think September 1st is probably about the right time frame to have this in-court hearing to begin lodging those objections if she has any. My next question is, are you expecting the physical evidence to be brought here into court by a CSI so that she can potentially open it? Or are we just talking about digital evidence and giving her a list of the physical items?
If there's physical evidence that's sought, I want her to have the opportunity to review it.
And we should be looking at the top of the month for September so that we can get this done.
Okay, all right. Ma'am, do you understand that what it is that I'm discussing right now, so that you have the opportunity to review the evidence that the state may be seeking into evidence in your trial?
Is it my understanding that they will supply me with a USB drive and then I am to review it while in court?
No, ma'am. So it's kind of a two-step process. So anything that's digital, that's not forensics or CSI or something that's tangible, will be provided to you on a USB drive. We also will have a hearing where all of the evidence, including any digital, electronic evidence, or any tangible evidence, CSI materials, will be shown to you in court, played to you in court, so you have the opportunity to review it here as well. Anything else will also be given to you on a thumb drive for you to review at your leisure based on the hours of 8 to 4 by the laptop at the Orange County Jail. And then we will have a deadline after we have this evidence viewing for you to identify in writing any objections that you have to any of the evidence that's been provided by the state.
So it's not a matter of any type of confidentiality, it is all done in the courtroom with everyone?
It would be in the courtroom, correct?
Are there going to be news cameras and photographers?
That's something I need to address. I do not want, because our jury pool is going to be coming from Orange County, I have concerns about the media's presence in the evidentiary viewing. So I may have to enter an order which would prohibit media access for the purposes of that hearing due to the nature of what is being produced and reviewed, so as to further prevent intimate details of the case being released prior to trying the case.
Understand that, Judge. Ms. Boone, not to turn the page completely, but I think it's pertinent to this discussion, has indicated through some counsel that had met with her recently that she wants to talk to the state out of the jail. And I was going to discuss that at the end, but perhaps to not waste the court's time, I don't know about bringing physical evidence out to the jail, but as far as the digital evidence, which will include autopsy photographs, which will include crime scene photographs, which will include videos, perhaps a different suggestion, especially since she has an investigator from Prison Break, is that we identify those files that we intend on introducing at trial so that they can review that digital evidence on their own in the jail, and we're not publishing all the digital evidence here in open court. That should allow her the opportunity to lodge any potential objections, such as duplicative or any other objections she may want to raise about autopsy photos, so on and so forth, without exposing all of the digital media to the public. As far as the physical evidence, the state doesn't have any real concerns about the media covering that. She can open those exhibits, or somebody with scissors can open those exhibits for her if there are any exhibits she wishes open in the witness box where it's concealed from the media's eyes. So those are my suggestions, and then later we can turn to her request and put on the record how we would go about going out to the jail and meeting her.
The only concern that I have with that is I don't have a record as to what it is that she reviewed.
My suggestion would be that because this is in the context of plea negotiations potentially, I would be out there, Mr. Cacciore would be out there, and our investigator would be out there, and we would record it. The conversations that we have, of course, and that would all be protected because it would be in the spirit of plea negotiations under the evidence code. And then we can all file in writing, the state can file in writing, these are the videos that we are going to use. These are the particular photograph numbers from the crime scene and from the autopsy photographs that we're going to use. And then we can have the defendant sign off on that as well, so that it's documented as to what was told that she would be facing at trial. And either she can review it with her investigator or she can review it with us, being present, and then that way the digital evidence is now in the open.
Okay. Ms. Boone, what are your thoughts on that?
I'm a little lost. So it's an option of reviewing what the state has with my investigator and then be able to come with the objections and everything.
That is correct.
I'm clear on having all of my evidence being in sealed bags and for me to be able to inspect them to be here in the courtroom. I don't know how the attorneys have done any of this prior, but I don't believe that it was in the courtroom. So I'm just trying to protect myself against the media. I'm not sure at this point what is even suppressible that is available on the internet. But at the same time though, it is my understanding that I should have some right to privacy in reviewing the evidence. So I didn't know if my investigator and I are able to collaborate prior and view and then come to court with everything finalized and ready to go with answers.
I'm certainly going to give you an opportunity to meet with your investigator to address it. The question is just the method of how to do it. The state's proposal is digital. They would meet with you, identify specifically digitally what videos, what photographs they intend on utilizing, and anything that may be physical, CSI, et cetera, would be addressed here in open court.
Just so the court and the defendant understands how physical evidence viewing would operate normally, the defense attorney and or her or his investigator would come out either to the sheriff's office or OPD's evidence center, whichever agency, and they come and view it, but it's done in the presence of the state, it's done in presence of law enforcement, it's done in presence of the CSI for the chain of custody. So attorneys don't get privacy when they're reviewing the physical evidence either. So that wouldn't really be any different than if she's doing it in the witness stand or wherever you deem suitable in the courtroom.
I think that's the most appropriate way to have the opportunity, ma'am, to review the evidence. I can't release that evidence to Mr. Lane to bring to the jail for your review because of the chain of custody issues concerning some of the physical evidence. So CSI would have to be here just like an evidence viewing at the sheriff's office or elsewhere where counsel just identified. And I cannot bring you anywhere else other than here, and I can't release you to anywhere else. So I think the only solution that we have is to have the evidence viewing here with regard to any of the physical evidence.
Why is it that it can't be transported anywhere other than here?
Because I cannot make a record anywhere else of what you saw or what was reviewed. The only opportunity for me to make that record is here in court.
What did prior attorneys do?
That was already identified by the state.
I know I'm trying to keep up with everything. What was the answer, please?
So an attorney who's doing an evidence view would come out to the law enforcement agency's evidence warehouse, for lack of a better term, and then in the presence of the state attorney, the CSI, and the lead detective, they look at the package, and if they deem any particular package worthy of opening and examining, they can do that. We can have the CSI bring a butcher paper here so that any particular item can be opened, put on fresh butcher paper, and then changed out between exhibits so that there's no contamination. And then you can examine it. if Mr. Lane or any other representative from his organization is here, he will have the opportunity to photograph those exhibits once taken out of the packages. And that's essentially how an evidence viewing is conducted.
Thank you.
You're welcome.
And again, please, would the media be involved in that?
That's a conversation that I need to see if I can exclude them from participation or viewing that proceeding. There are rights where the media has to view proceedings in court, but due to the sensitive nature of what may be being discussed or viewed, I need to see if I can prevent media access. So without doing a little bit more further dive or research in that, I don't know if I can make that call at this time.
Yes, I have not heard of a case where the evidentiary hearing has been televised.
Oh, really, Sarah?
Um,
With all your legal knowledge?
I disagree with the media being involved in that.
I understand your position, and again, for the reasons that I stated earlier, I'm trying to prohibit as much as I can from dissemination to the public, especially some of the exhibits that the state may be seeking to utilize. We are going to go ahead and set the evidence hearing. The first is Sunday. September the 1st is a Sunday, and that is Labor Day. The court would be setting a hearing for Tuesday, the 3rd at 9 a.m. to have the physical examination here in court. At that time, the USB drive or the after our viewing here in court, state, is it your position to then have that meeting with Ms. Boone and her investigator and your investigator under the plea negotiations or settlement discussions auspices to review all of the digital and identify what it is specifically?
We are happy to defer to the defendant's wishes on that. And I wanted to have that discussion. It seems like we're turning that discussion. So I'll leave it in Ms. Boone's court. My indication from one of the attorneys that she had discussed things with said that she wanted to have a conversation with us. And so I'm offering that up. In the past, with female defendants at the Orange County Jail, there are classrooms, or at least one classroom there, where we could arrange to meet. It would be a big enough room for 4 or 5 of us that would need to be there. And then we can discuss that, whatever it is she wants to discuss, and it would be recorded. And again, those portions of the conversation that are about plea negotiations and the evidence and whatnot in the trial, I believe under the evidence code would not be admissible to be used against her. And I can leave it to her when she wants that to happen. We can make arrangements to try and accommodate that. It should not take us very long at this point, given the age of this case, to select and identify which digital evidence exhibits we're going to use. It's simply a matter of getting rid of duplicative and irrelevant photographs from the scene and the autopsy. And I believe the videos won't be too hard to decide which ones to use. I don't know that.
So I just want to clear up one thing for folks out there. The issue with the attorneys is the fact that they're appointed. So she's being appointed public defenders. Okay, that's different than like if some fool attorney decided, yeah, like her little flyer really struck me. I think she's right. I'm gonna get real famous off this case. I'm gonna take it. The judge isn't going to stop her from getting private counsel. What happened here is the judge is done using public funds to appoint her public defenders. So just be clear on that. Like at any point, some private attorney can come in, enter their appearance, and the judge isn't going to say, no, you can't have an attorney. What this issue is specifically is that we're talking about public defenders, and that's that. So I want to take just a minute to go through the case that the judge first cited, which is State v. Paul. It's a Florida case, and it's out of their 4th district down there. And basically they break it down. So the defendant in that case there were charges that arose out of an altercation between a defendant and a victim. The defendant shot and killed the victim in her car and shot another victim. The details of the incident are irrelevant to the issues to be addressed. So during pretrial hearings prior to trial, the defendant was assigned a public defender. Conflicts arose between them as to how to proceed with the case. And I had seen somebody make a comment about conflicts. Conflicts, when it comes to this type of issue, doesn't have to be that I've represented this person in the past, or I've represented somebody that is a witness for the state. Those are one type of conflicts. The other type of conflict is where there's irreconcilable differences between you and your client, where you can no longer function as a team in terms of providing them a defense. So that becomes a conflict that is not fixable. And typically no judge is going to force an attorney to stay in that situation. You know, a lot of times with private counsel, we're not allowed to say, oh, well, you know, we had a fee agreement. This is how much the person was supposed to pay us. And we were on a payment plan throughout the course of the pretrial period. They've stiffed us and we want out because we haven't been paid. Like you can't say that outright for various reasons. But in situations like where the attorney-client relationship is devolved to the point where you cannot function at all with that person, they're typically going to let you out. And that's what happened here on repeat. So to keep moving through this Paul case, so the conflicts arose between the two of them and how to proceed with the case, which I get the sense that that's what's going on here. I think that Sarah wants this case to be handled in a certain way. And I think that there's lawyers that are coming in, looking at the evidence and are saying, okay, well, that's not going to work. You know, like that is not your best defense here. And she's playing the smartest person in the room role, telling them, fuck you. That's not how I'm going to do it. That's not how I want to do it. I don't agree with that. So at that point, you have a real issue between attorney and client. So in this particular case, the main disagreement involved the defendant's desire to expedite the case for trial. While represented, the defendant filed a pro se demand for a speedy trial, which his counsel moved to strike. The defendant then decided to represent himself and discharge counsel. Okay. And there's a footnote here saying that the trial judge transferred the case to the mental health division for a competency determination before proceeding. The defendant was found competent to proceed. So after discharging the counsel, the defendant again demanded speedy trial, noting that it was his choice. The judge asked the defendant whether he thought, quote, it would be beneficial to give himself an opportunity to do some discovery, end quote. The defendant declared that he was ready and had demanded speedy trial months ago. The court set the trial with the assigned public defender appointed as standby counsel. So here's the standby counsel issue that he denied this morning. At a subsequent hearing before a trial, the judge conducted a Ferretta hearing. Okay. And that's what the judge was talking about here, where that's where you have a situation where the defendant, like Brooks, was saying, I want to defend myself. I've got the right to defend myself. I don't want no stinking lawyer. I want to defend myself. Here, you had Sarah at some point say she wanted to defend herself. And now she's reversed course, because I'm here to tell you, I don't give a shit how many trials you watch as an observer. Unless you go to law school and you learn the rules of evidence and trial advocacy, you are going to have no idea what you were doing. It's incredibly intimidating. I went to law school, passed 2 different bars in 2 different states, and walked out like in our first civil trial and had no idea what I was doing. It was terrifying. It was like, you don't know how to file motions. You don't know how to put a caption on. You don't know what it's supposed to say. You don't know the rules of discovery. You don't, like, she's got to try to read through as much as she can. And every prison has legal books. They have law books in there. You know, she may have access to either Lexis or she may have access to Westlaw. I don't know. She is in a position now where reality is setting in. You know, it's one thing to write up, 16-page motions where she's just pontificating and using big words and sounding smart. And it's another thing entirely on knowing what the hell you're doing when your life is at stake in a court of law. And she's realized at this point, she has no clue what she's doing. She's overmatched. She's not going to be able to give proper objections. And the rule with objections is like, if you fall asleep in court as the attorney, the first thing that you do when you wake up is you object. You just assume that you're objecting all the time. I don't know what this judge is like. If she were lucky enough to have a Judge Bev type ruling, wherein Judge Bev says, not only do I not want speaking objections, but also I'm not allowing you to give a basis, that would be a godsend for SarahBoone, because she'd just be able to object without having to articulate what her basis in the law is as to why she's objecting. And then on appeal, she can just let the appellate court figure out what proper objection fits there, which is one of the issues with Allie and I were talking about it with the Karen Reed case, that on appeal, it's not a good look for the judge not to have a basis, because it gives the appellate court way more leeway in terms of finding objections to be properly sustained or properly denied based on their ability to pigeonhole certain objections into any objection that they feel fit. You know what I'm saying? Whereas, like, typically if I'm going through a trial and, like I said, okay, objection, lack of foundation, like meaning that before they're trying to put this testimony on about when something happened, like an occurrence, but they've laid no foundation in terms of, okay, this was on August 3rd at 10 p.m., blah, 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 laying a foundation of what they're about to talk about. And I object, lack on foundation, but I can't give a basis. And in the appellate, it goes up to the appellate court. The appellate court can look at all the available objections and say it was denied against me. They said they laid proper foundation and something got into trial that I felt that shouldn't, because the appellate court has the ability to say, okay, look, we have the ability to look through all the available objections, and we find that this one fits and it was properly sustained. That just gives the appellate court a lot more wiggle room, which typically you don't want as a defendant. Like, you want your lawyer to be objecting and to be able to give a basis. She's just not going to have any idea. I mean, like, she's going to be able to Google objections, but I'm just telling you that the hearsay rules are so complex. Like that, like in our evidence course, that probably was half the semester was just dealing with hearsay and trying to get a grasp on hearsay, because it's super complex. It just is, because there's things that are non-hearsay and there's exceptions to the hearsay rule, which are different things. So, her being able to have a grasp on the rules of hearsay in terms of her trying to file any kind of motions in limine, trying to keep out evidence, is going to be overwhelmingly difficult for her. She's just not going to know, because people, like, they watch TV and they think that that's what real trials like, that people can just pop off and talk about whatever the fuck they want to talk about and give long diatribes. And you can't do that. That's not how good, like, we've all watched enough to know that there's rules that you can't just do that. Now, and it gets really weird, like if she decides to call herself to the stand, because she'll be able to give like kind of a narrative where typically it's a direct examination, but there's not going to be a lawyer there to ask her questions. So the judge is going to allow her to,
Wait, so you're saying she doesn't have to sit on the stand and then run over to the thing and ask a question, then run back? That's how it works?
I think that they should make her do that.
Yeah.
Because that would be amazing. No, I'm kidding. No, she'll just be able to sit on the stand and kind of go through her thing. And then when she's getting cross-examined, if she does testify, you know, if she's going to be objecting, she'll have to object from the stand. And what do you want to write, Sarah? As long as you're not trying to put me up for it, Sleuthy, just keep me out of it. I have no interest in representing Sarah Boone at all. But you know, it's just it's going to be a very, very clunky trial. So I want to keep going through this Paul case just so you guys kind of have an understanding of this standby counsel issue with her. So I left off here. At a subsequent hearing before trial, the judge conducted a Feretta hearing and explained the defendant's right to have an attorney represent him and the benefits of having an attorney. Because of their ongoing disagreement, standby counsel also moved to withdraw. Okay, so and this looks like this is the note or the motion, the motion that came from standby counsel. And it says, Judge, I understand why we are appointed. It's to assist the court. So I don't want the court to think that I am not trying to help out with that. I just feel we were the public defender's office. We withdrew the last time. Mr. Paul wanted to represent himself. So the public defender's office withdrew, but the court appointed myself as standby counsel, which the court has discretion to do. I just feel, but the purpose of that would be to kind of help the process move along. The judge responded, no, the purpose of standby counsel is if this gentleman ever has an epiphany during the course of the trial, someone is available to step in at that moment and say, okay, I will finish the trial. Okay, so you get what he's saying there. It's not necessarily giving tips during the trial itself. It's if the defendant realizes, oh shit, I'm screwed. Like, I have no idea what I'm doing. And I'm about to go down the river for a really long time because I made a terrible, terrible mistake. I want this guy to start repping me, or this lady to start repping me. So that's what standby counsel's for. Standby counsel would then explain that would not be that he would not be able to resume the trial for the defendant should the defendant decide to let him take over. We would not be prepared to go to trial. I would waive speedy trial if I were to take over and properly work up this case like it should be. So that's an interesting issue. It's like we talk about that with the speedy trial demand. It's a right. It's the defendant's right to demand speedy trial, but it can put the state in a precarious position in terms of forcing them to trial early. But like I say all the time, that's a two-way street. It's a double-edged sword. You know, it's also forcing the defense to go to trial way early. So, which is a disadvantage. And that was a perfect example of that lawyer saying, look, you could have me standing behind this person and I'll be hearing what's going on at trial. That doesn't mean that I'm prepped to go to trial, especially because there was speedy demand. I haven't been able to properly prepare. I haven't been able to do my investigation, review all the discovery, all the things that I need to do to be able to prepare for trial. And that hasn't taken place. So I would still be seeking to kick the trial date. Like I'd have to ask for a continuance, which then comes into direct conflict with the speedy trial demand. So it creates a real issue there. So the court then asked the defendant, so it's court, quote, a lot of people think it's helpful to do discovery in order to prepare for a trial. Do you agree with that? The defendant, yes, ma'am. I went through all my discovery. Went through my whole case. Court, okay. And you are good with whatever you have? That's your position. The defendant, yes, ma'am. So judge put that on the record, which is important, made that record. The defendant decided that he did not want his public defender to stand by counsel. I don't want him to stand by. I don't need him standing by no one, period. I don't know why he is in the courtroom today anyway. End quote. The court granted standby counsel's motion to withdraw, but before doing so, the court found that standby counsel was an experienced criminal defense attorney. And here's some more quotations. The court, and that is at the defendant's specific request that you not even have standby counsel. Is that what you were asking for, sir? The defendant, I asked for co-counsel. The court, well, you're not a lawyer, so you can't have co-counsel. The defendant, if I request to discharge my counsel, why would you have him as standby? The court, in the event that you change your mind and you don't want to represent yourself as a pro se non-lawyer. The defendant, that won't happen. So then ultimately, on the first day of trial, the court conducted another Feretta hearing, reviewing the defendant's highest level of education, whether he was under the influence of drugs and alcohol, and whether he had ever been declared incompetent. The court again emphasized the benefits of having an attorney. After a brief recess, the court conducted yet another Feretta hearing. The defendant stated that he wanted to represent himself. At this point, the elected public defender for the circuit intervened. She advised the court that she had spoken with the defendant and told him that if he wanted standby counsel, it would be assigned the assigned public defender because no one else knew anything about the case. The defendant then decided that he did, in fact, want standby counsel. The court reappointed the same public defender as standby counsel. The defendant conducted his own opening statement, with the state lodging an objection after his first sentence. It's how it's going to go. The court reminded the defendant that he had demanded a speedy trial, and it was time for the opening statement. After the defendant cross-examined the first witness, the court held a sidebar with the state and the defendant. While it is unclear from the record, it appears that the defendant began consulting with standby counsel. The court, and this is some more quotes, the court, Mr. Paul, you are entitled to represent yourself. You are entitled to have standby counsel. You don't have anything in the middle. So if and until you elect to bring your standby counsel back on board, you can't consult back and forth. He's either in or off. So do you want him to represent you? The defendant, I got the names confused of the officers. The court, well, I don't know what to help you with. You can either be represented by an attorney or not. The defendant, so what? Waive my trial? Is it going to waive? The court, the witness is gone. Whether you want to call him back, that's up to you, but you can't straddle the fence. You either have standby counsel or you don't. He is not consulting with you. I'm going to have him sit in the back of the courtroom up until the time. The defendant, if I say I want an attorney, I go stop. Court, no. The defendant, that's what I thought. I was going to continue my trial if I bring him on, I thought. That's what I thought. The court, you want standby counsel to assist you or not? The defendant, yes, ma'am. The court, you do or do not? The defendant, yes, ma'am. The court, okay, standby counsel. And then standby counsel comes up. This is what I talked about last week. The defendant, I want to continue. Standby counsel. In order for me to properly represent Mr. Paul, work has to be done. We have to take depositions. The court, that's not the way it's going to work. Mr. Paul made the decision. He has been in court every single time. We have gone through the colloquy. We've talked about the education, the fact that he reads and writes English. We talked about the pros and cons of having or not having a lawyer or having a lawyer. Couldn't really think of any pros of him representing himself. I advised him all along that, yes, he understands that the question every time he comes into court. Yes, he understands. We have had it 3 times today. Yes, I understand that. Then if at any point Mr. Paul changes his mind, you step in, you go forward. Mr. Paul has created the situation. Standby counsel. I understand that, Judge. I'm not trying to argue with the court. I'm in no position to take over a first-degree murder. I have had the case 6 weeks. I am not in a position to effectively represent Mr. Paul and going forward right now. So the defendant requested to have his standby counsel represent him. Standby counsel immediately moved for a mistrial, reiterating that he was unprepared, which is the exact same thing I would have done. It's the exact same thing I would have done. Like in case, like I've had to tell judges we've had 2 big trials set at the same time, and like neither judge has been willing to move the other trial, despite like one of the cases being longer in the tooth and we're like, we're not prepared. We are not prepared to go to trial. We are not prepared to go full speed. We have two trials that we're trying to prepare for that are going at the same time. We can't be in the same courtroom at the same time. Like I'm seeking a mistrial here, and that's like before a jury was impaneled. Ultimately we got the continuance, but still it's like, you can't go to trial if you're not ready. It's going to be a bloodbath, or it's going to be overturn an appeal because the attorney's gotten on the record saying I'm incompetent at this point to handle this trial because I just don't know the case well enough, So standby counsel immediately moved for a mistrial, reiterating that he was unprepared. The judge denied the motion. Standby counsel then requested a continuance until the next morning, to which the state objected due to witnesses who had traveled to be at trial that day. The court denied the motion for continuance. The trial continued with standby counsel now representing the defendant. After the state presented the testimony of another witness, standby counsel again moved for a mistrial. I am not prepared to effectively cross-examine this particular witness. The trial court denied the motion. At the end of the first day, standby counsel again moved for the mistrial. The court, do you have any type of authority that would support the fact that this gentleman has been through umpteen Feretta hearings, has always said, even went so far as to say that he didn't even want you involved as standby counsel. He's been evaluated to see whether he's competent. He's competent. It's his choice. He can make his choice. He made it. So this is the position that he's in. We're going to go forward. I'm not frustrated or anything with you. I understand you are laying a record. That is the position Mr. Paul has found himself in, based on the decision that Mr. Paul has made throughout the course of these proceedings. Standby counsel, it's just a matter of defense being prepared for trial. That's all. I'm being ineffective. The court, well, I don't think that the ineffective, that the fact that Mr. Paul elected to discharge his lawyer, demand a speedy trial, go to trial without having any discovery, that's his choice, because he had multiple Feretta hearings. And in fact, when he filed the Nelson hearing, you said you wanted to take time to prepare for the case. I didn't even let him have the Nelson hearing until he was evaluated to see whether or not he was competent, whether it's a good decision or a bad decision to represent himself. That is a decision that he's entitled to make, and he made that. And then so on the second day of trial, standby counsel renewed his motion for a mistrial. Again, the defense got appointed. This is standby counsel. The defense got appointed with no preparation done in this case whatsoever. Yesterday I was cross-examining witnesses. I don't even know who they are. Oh my God. The state judge, I think this was not unexpected, and the defendant put himself in the position by demanding a speedy trial, by asking to represent himself, and by having the trial started. And even one or two witnesses, I don't remember how many already testified by the time he has now decided to have a lawyer. So because he has put himself in this position, he is not entitled to change the way that the court is able to administer justice by asking for a continuance, trying to establish error. So we would object to any motion for a mistrial being granted. So the court denied the motion again. And after the state rested, standby counsel moved for a judgment of acquittal, arguing the state failed to make a prima facie case. The judge denied the motion. The defendant briefly testified that he was already out of the state when the shooting occurred. Standby counsel then again moved for a judgment of acquittal. Judgment once again denied the motion. The jury found the defendant guilty of first-degree murder with a firearm, aggravated assault with a firearm, shooting into an occupied vehicle, and possession of a firearm by a felon. Court sentenced the defendant to life in prison on the murder charge. So then on appeal, the defendant argues that the trial court misunderstood the role of standby counsel and erred in not allowing him to ask questions or otherwise communicate with his standby counsel. He contended that because of the court's improper restriction, he was forced to give up his constitutionally guaranteed right to represent himself. The state responded that the trial court clearly advised the defendant of the reason she was appointing standby counsel, and she had the discretion to do so. And that this issue is not preserved and is based on speculative grounds. So then it gets into the preservation of issues for appellate review by first raising them in the trial court via objection. Here, the defendant did not object to the trial court's restriction on his access to standby counsel. In fact, on more than one occasion, the defendant discharged standby counsel. This claim is therefore unpreserved for our review. That's what I'm always talking about. Like, you fail to object, you fail to preserve issues, you're screwed. You're screwed. There's just, you're done. The issue has been waived, and they're not going to address it, which is why you hear objections constantly. You know, you're always trying to preserve those issues for appeal. Even if the defendant had challenged the restricted use of standby counsel, we see no error in the trial court's appointment of standby counsel for the purpose of conducting the trial. Should the defendant change his mind about his representation, we review the trial court's decision regarding the right to self-representation for an abuse of discretion. So, and then they get into the role of standby counsel. With some limitation, a defendant in a criminal trial has the right to self-representation. That's Supreme Court case. It's at Ferretta v. California. A defendant who has decided to represent himself bears the entire responsibility for his defense, even if he's appointed standby counsel. So that's interesting. So the defendant who decides to represent himself bears the entire responsibility for his defense, even if he's appointed standby counsel. And that's Bear versus Bell, which is a Florida case. A defendant has no constitutional right to standby counsel, Jones v. State, and the trial court has the discretion to appoint standby counsel. No defendant has a constitutional right to hybrid representation. That's Shepard v. State, which I think the judge also quoted. A criminal defendant is entitled to change his mind regarding self-representation, but it is, in quote, implicit in Ferretta that the right to appointed counsel, like the adverse right to self-representation, is not a license to abuse the dignity of the court or to frustrate orderly proceedings. And a defendant may not manipulate the proceedings by willy-nilly leaping back and forth between the choices. That's Brown v. State. In fact, standby counsel's role has been described as, quote, assisting the court in conducting orderly and timely proceedings. The Supreme Court of the United States touched upon the role of standby counsel in both Ferretta and McCaskill v. Wiggins. In Ferretta, the court recognized that a trial court may, quote, appoint a standby counsel, end quote, to aid the accused if and when the accused requests help, and to be available to represent the accused in the event that the termination of the defendant's self-representation is necessary. That's what I was saying. Like, here in Illinois, like, typically the judge, like, I don't have to come in and try the case. I could be behind him, the defendant, and give advice if they're asking. This judge is like, no, he's either in or he's out. There's no consulting with him. And the court found that was within the judge's discretion. So in McCaskill, the court further explained a defendant's Sixth Amendment rights are not violated when a trial judge appoints standby counsel, even over the defendant's objection, to relieve the judge of the need to explain and enforce basic rules of courtroom protocol, or to assist the defendant in overcoming routine obstacles that stand in the way of the defendant's achievement of his own clearly indicated goals. Participation by counsel to steer a defendant through the basic procedures of trial is permissible. So our Supreme Court discussed standby counsel in State v. Knight. There, the state appealed an order vacating a death sentence and granting the defendant a new sentencing proceeding. The defendant cross-appealed and filed a petition for a writ of habeas corpus, asserting that 5 claims of ineffective assistance of appellate counsel. One of those claims was the failure to raise any issues regarding the limitation on his use of standby counsel during the trial. The court reviewed the transcript and found the defendant specifically refused assistance of standby counsel and wanted to make sure that there was no insinuation or appearance that was in any way acting as his counsel. The court found it clear the defendant did not want to appear that he had acquiesced to the limited role that his standby counsel performed. The court denied the petition. Similarly here, so that's what they do when you're reading case law. They'll give you the case law in terms of precedent. They'll give you kind of the factual scenario that happened in that case, and then they will apply it to the law. So if you're ever reading, or to the case at the bar, which is here, so you'll always see that. You'll see some cited cases, some rules of law, and then they'll try to apply it here. So similarly here, the defendant refused standby counsel and in fact had discharged his lawyer before and after his lawyer was appointed as standby counsel. Quote, I do not want him to stand by. I do not need him standing by no one, period. I don't know why he is in the courtroom today anyway. End quote. We fail to see how any limitation on the use of standby counsel can now be argued when the defendant made clear that he did not want standby counsel. So that's how they overcame the judge's decision to not let standby counsel give tips. That it was an all or nothing proposition. Either standby counsel's coming in and they're going to handle the case and you're going to be with them, or they're not. So we acknowledge the Herculean effort of the public defender to help this defendant before and during the trial. At every turn, the public defender gave sage advice to forego a demand for speedy trial, to properly prepare for trial, and to undertake discovery. Unfortunately, that advice went unheeded by the defendant. We also acknowledge the patience and diligence of the trial judge to ensure the defendant was competent, aware of the advantage of having counsel and the disadvantages of representing himself, and give him multiple opportunities to reconsider his decision. In the end, the defendant chose to represent himself. The outcome was not unexpected. Given the defendant's choice, which is guaranteed by the Constitution, we see no error in the court's handling of the standby counsel or any other of the issues otherwise raised. So, I mean, there you go. It kind of gives you a basis on the standby counsel issue. And it's at this point, like that the case law makes it clear it's not a constitutional right to have standby counsel. So like it is literally going to have to be private counsel that's going to enter a pro bono appearance for her if she's going to get a lawyer, because this judge is clearly like absolutely not going to change his mind about appointing counsel. He's like, in like 8 lawyers, man, that's a lot, dude. That's a lot. I mean, SarahBoone's the one who attacked one of her first lawyers in court, right? I think I did a show.
No.
Who was that?
Of the one who cut off the head of what you got. I'm sure someone in chat.
Oh yeah.
That's
right. Yeah, I did a video with some Cypress Hill.
Shabusiness. There it is. Shabusiness.
Shabusiness. That's right, Taylor Shabusiness.
But dude, all I could think about when you were reading the case, what happened in the first case, is similar to the divorce analogy we did before, but just way worse. All I'm thinking about during that trial is the family of the victim, any family members of the victim that are watching this guy during that trial, the initial case, who are probably like, are you fucking kidding me? This fucking guy's gonna pull this shit, and we got a dead family member. Same with SarahBoone. It's been 4 years, and now she's gonna pull this shit. Like, I know, I understand, like, she has rights, but like, I'm just picturing the family in that trial you described, just being like, this fucking guy he wants counsel, he doesn't want counsel, he wants counsel. He's just gonna delay this shit forever. They want a mistrial, and I'm, same with Boone. Like, how far are they gonna push this shit down where they finally have like, no, like
that's exactly the rationale that the judge is using. It's like, it's done. It's over. Like you done fucked around too much, and now you've shit the bed. Now you've made your bed. Now you're going to lie in your shitty bed. And that's the way this is going to go. So, I mean, short of it, like, and to be honest, if somebody comes in pro se or pro bono rather, and says, okay, I'm going to handle it, I don't know that the judge will give that lawyer a continuance. I mean, he might, but you're still coming up against the same issue, because like you got private counsel coming on now. That counsel can say, I need to review I have to review everything. I can't go to trial. Just you say, you know what? Like, you knew that. Like the judge would warn them, like when they're entering their appearances, like, I'm not going to give you a continuance. This matter is February of 2020. It's over 4 years old. Like, it's going. This thing is going in October. So, you better think very, very long and hard about whether you want to enter your appearance right now, which then, I mean, are those going to be appellate issues? Absolutely. Are they going to be winnable appellate issues? I don't know. Like, I'd have to look through all the Florida case law in terms of that type of situation, but you know, I mean, ultimately, I mean, this thing, I mean, she's gonna get convicted. She's like, she should get convicted. I mean, she left the dude in there. You know, like my defense would 100% be some kind of either battered spouse syndrome or, hey, hi.
Grandpa wants a BLT. Do you know anywhere I could get a BLT?
Oh, hold on. My dad needs to eat. Hold on. Wow.
While he does that, get some BLT, sets up Moneyball for him to watch TV. If you guys haven't hit that like, please hit that like button. As we are going over the latest appearance of Sarah Boone, who is now pro se. Her trial, if it is not kicked, is going in October.
Don't mess with anything.
What's all true?
Whatever you were saying, she was saying was all true.
She's right. It was all true.
All right, you guys got that figured?
No.
All right,
We
goodbye.
don't want to go to Calamity Jane's.
Okay, well, go somewhere else. Figure out where you can get a BLT. Or just go buy bacon, and I can make it. And lettuce. If you get a head of lettuce and bacon, I can make it. Actually, they're delicious. I would eat one myself. So, yeah, like it's like this is going to be a shit show. This is going to be an absolute shit show. All right, let's continue listening. I just wanted to give you guys some basis in the law so you had a better understanding. Hopefully reading the case wasn't too boring for y'all.
Who wants a BLT now that
Okay. All right, ma'am, do you
the whole
have,
chat do it poll.
a thought on when you would like this viewing to take place at one of the classrooms at the Orange County Jail under the concept as identified by the state?
So this meeting is separate. This is prior before everything else.
What I would envision, to not waste anybody's time, is we can go out there and have this discussion. If there is a discussion to be had about plea offers, one of the other topics was other matters, so that's kind of ambiguous. I'm not sure what other matters are. And then also we can let her know and probably provide the court in writing a list of the digital evidence that we seek to introduce. And then that way, if she wants us to review those digital evidence items together with her in the presence of everybody, we can do that. Or we can let her, with the list of the digital evidence that we plan on introducing, review that as many times as she wants by herself and or with Mr. Lane.
I understand. So would I be leaving with the digital evidence today, or how soon may I receive that?
So the state needs to assemble that. So my thought would be to have that meeting, ma'am, on the 3rd of September. So we would have a hearing at 9 o'clock in the morning where the physical evidence would be reviewed here in the courtroom. As soon as that evidence was finalized and reviewed, the state with their investigator, yourself with your investigator, would then meet that afternoon at the Orange County Jail to address, as the state has identified or spoken about, any settlement negotiations, plea offers, and under the other category to address what the digital exhibits are. They would provide you those on a USB drive, and they would identify for them specifically what it is that they are seeking for you to review at that point in time and have the ability to review it afterwards.
We're happy to do that beforehand, and I just want clarification. By providing her the USB with all the narrowed down exhibits out of discovery, are we providing it to Mr. Lane? How are we?
It would have to be provided to Mr. Lane, who would then have to provide it to a member of the staff at the jail, the names of which I have from the captain at the jail as to what persons are involved in the laptop process. And then once that's done, I would require Mr. Lane to identify with a filing in the court, probably in the form of an affidavit, as to when, where, and how the USB drive was received by him, and when, where, how, and to whom it was delivered.
Thank you.
Your Honor, I feel uncomfortable with you supplying my evidence to the jail. So I don't know if there's a way that I don't know if you are aware, but my jail phone calls have been released, and there's a lot of things that have been released from the jail. So I don't know. I do not feel protected by you all handing it to the jail. I know that Mr. Lane and I previously have worked on the laptop with USB drives that he has furnished himself from bringing in from the outside. So I didn't know, and I would feel more comfortable if there was a process or a procedure. I don't know who your names are from the jail. I do know the captain, whom I spoke to the other day regarding my laptop. But I would very much.
Who was that, ma'am?
I'm sorry?
Who was that?
For which?
The captain that you spoke to. Who was it?
D. Giovanni.
Okay.
There's multiple sergeants involved, and I did meet the gentleman who was supposed to be here today to pick up the USB drives. So I don't feel comfortable, please, with providing the USB drive of my evidence with things that have been leaked or released from the jail. So if there's a possibility, please, I would like for my investigator to have that and bring in with me prior.
If I understand the jail's protocol, which I read to you at our last hearing, the jail will keep custody of the USB drives and release them with the laptop as well. So I don't know how I can bypass that process that they've created, because the USB drives and the laptop, when it's checked out by you and when it's returned by you, is all going to be logged in their IMS system.
Right, it's simply a laptop. It's a very basic laptop where anyone affiliated with my case has any type of digital evidence they bring in with them from the outside. It's simply a basic laptop that we are able to utilize at the Orange County Corrections Department. That's how we have done that prior. So I don't know what it is different, and I don't know the jail protocol because no one's included me.
You were provided a copy of it through the court filing, and I read it to you at the last hearing.
Your understanding is different than my understanding because my contacts from the jail are telling me something different.
Who? What are their names?
There's multiple sergeants.
What are their names?
I'd rather not get them involved with fear of harassment or anything from other.
Ma'am, I'm deferring to what the Orange County Jail and the captain that you identified specifically as.
Bob, before you go any further, you're muted.
To answer Tara's question, at this point, it's going to be a disaster for her. Do you think it would make more sense for her to take a plea? She might get less time. If she doesn't, she's already got 4 years in. I mean, it depends. She's having this meeting. Like, so we know that she's going to be having, sounds like they're going to come to the women's holding facility. They have a classroom. They're going to meet. And it sounds like they're going to go through some plea negotiations. If they're willing to drop it to a manslaughter, if I'm her, I'm running with it. I mean, the difference between manslaughter and second degree murder, that's if they're willing to do it. You know, like they're like, because her whole case, if she's not going to be giving or using some kind of mental defect defense or battered spouse syndrome, and she's not really a spouse, but I think it would still apply. Like I would certainly entertain the issue because like all she can say is it wasn't her intent, that, you know, she didn't mean for him to die. She didn't think that he wasn't going to be able to breathe. She thought she could get out. She thought that George could get out of the luggage, but you guys saw the video. I mean, that video is the evidence in this case. Like beyond that video, I don't know how much evidence the state has to put on, to be honest with you. In terms of her intent, the guy's begging to have her let him out. Begging. Can't breathe. Can't breathe. You know, and she just left him in there, right? So the answer for me is if I were in her shoes and they put manslaughter on the table with some kind of much more feasibly reasonable punishment, I'm jumping all over it. I'm all over that. There's no way I'm going to trial on it. I mean, she could look at life. She could get life on this thing, you know? I mean, with a minimum of 10.5 years or whatever it was. So, yeah, I think that she'd be wise at this point, which again, this move in terms of denying her even standby counsel at this point really is forcing her hand a bit in terms of she's coming to the reality that she's like way in over her skis, like she's just not going to be ready to handle this thing, especially if she thinks like she's in her mind, she's just stuck on this thing that, she thought he was going to be able to get out of there, just thought like he was full of shit. She should have been honest. Yeah, I was like, initially we thought it was funny. And then I'm kind of like when he said he couldn't breathe, I'm like, oh, well, then she started getting real shitty and vindictive, because it's like, the thing I don't know, and the part of the story that we don't know is like earlier in that interrogation that we were playing, she talked about that particular piece of luggage prior to this day was buried deep in this closet that she was talking about. Like if CSI went through that closet, they're going to realize that that's a closet we really need to clean out. It's a bunch of old clothes that nobody wears. It's a closet that's just got to absolutely be all pulled out, and it's got to be sent over to Goodwill or whatever. We got to donate the clothes. And, so the question becomes, how did that suitcase get out there? They're playing this game of hide and go seek. I mean, is the insinuation that George, in the process of playing hide and go seek, decided to dig the suitcase out of the closet, then bring it down to the most obvious place in the front room, and then at that point starts to zip himself in? Like, is that what her story is? I don't know, so I don't know. All right, let's keep going. So yeah, I would take a plea in a heartbeat.
By the way, I if she's found guilty, I think she should get life. Think about he's suffocated in a suitcase. Like
it had to have taken hours.
It had to be a long, like that has to be an awful, awful, awful death, man. I mean,
dude, it's like being buried alive.
Yeah.
Same shit. It's like the scene from Kill Bill 2 where Uma is like stuck in the casket, and like Quentin goes like full black on the screen, and all you can hear is like the dirt
on the
pine box. It was like one of my favorite. I was like, man, that was so effective. Like, and you could just hear her breathing. It's pitch black in the scene, and you just hear him shoveling the dirt and the shit on top of it. Man, that was something else. All right, let's go.
As to her memorandum to the court, which was read to you at our last hearing, which was sent a copy to you by a notice of service.
Bob.
And it was provided by U.S. mail. It was sent out last week.
I have yet to receive anything.
Bob.
Don't worry, I have a copy to give to you this morning.
Look at your text.
Just in case you have not received it.
Yes.
Can you hear me? Look at your text. You can keep playing, but your Allie wants you to look at your text. You're on mute.
The last thing I have is your order that you provided me with the implementation of your USB drive.
Okay.
Option.
All right.
So anything that you are speaking of in the meantime, I do not know, and it was served by process?
It was served by U.S. mail.
By U.S. mail?
Mm-hmm.
Yes. I actually have 3 motions, please, if I may submit them to you.
In a moment.
Yes, in the process of, because the address that you are, I'm guessing, sending these to is incorrect.
I received your letter addressing the address issue. That's been remedied. So the appropriate legal mail address will be utilized. It was simply a clerical error, and that has been remedied. But regardless, I did read to you at our last hearing the protocol for the USB drive in the jail. The court is inclined to follow the Orange County Jail's protocol with regard to the USB drives. So the evidence, digital evidence that the state seeks to admit at trial will be put on a USB drive, delivered to Mr. Lane. That will be delivered to a representative from the Orange County Jail. And Mr. Lane will thereafter file a filing with the court in the form of an affidavit identifying when he received it from the state and who he gave it to, when he gave it to, and what representative of the jail he gave it to.
So it goes from the state to Mr. Lane to the jail.
For the purposes of indexing it, for the purposes of their records under the protocol, and then it will be available for your use.
So if I want to see all of my evidence digitally, I need to contact someone at the jail.
No, ma'am. The evidence that were in the 2 bankers box that Mr. Lane digitized for you is going to be provided to the jail. That's going to be provided with the laptop to you. And that's available to you from 8 a.m. to 4 p.m. every day in the protocol that I read to you at our last hearing.
Yes, and I will speak to the captain just to be aware that everyone that it is in the process, because I do not feel comfortable with any of this, and I do not feel protected either by the courts or the jail system. So for right now, I don't know if it can be postponed or if it's something that I need to write another letter to. Everything takes longer in jail. So by me trying to get a hold of the captain nonetheless, it's going to be a feat in itself. So I want you to know, if anything, that I am in the process of trying to reach out to the captain. I don't know if she'll be here today or if it'll be the contact person. So in the process, I am working on speaking to the captain because I do not feel, like I said, that I am protected in any way, shape, or form by the Orange County Corrections Department withholding my evidence in any way, shape, or form.
Okay. The court's going to follow the procedure as I outlined at the last hearing. So here's what we will do. We will, on Thursday, September the 3rd at 9 a.m., we'll have a hearing to review the physical evidence. At that time, the state will provide its exhibit list, which will be filed with the court at that time, and a copy will be given to Ms. Boone of the physical and the digital evidence they are seeking to admit. After we have the in-court examination of the physical evidence, that afternoon, there will be a meeting at the Orange County Jail between the state, its investigator, Mr. Lane, Ms. Boone, to review the digital evidence and provide a USB drive with that information.
And can caveat in that order be unless it hasn't already been done? In case we do it ahead of September.
Sure, if you want to do it before, the deadline to do it will be to September 3. But the in-court physical examination will be at September 3. So if you all want to meet in advance of that, I won't prohibit that. Just file something in the court file identifying a notice or some document so that it identifies when that meeting took place, when the evidence viewing took place. Okay, thank you very much. Ma'am, after we've had this hearing on September 3, and that being the deadline for the digital evidence and the viewing of the physical evidence, the court would then like to set a deadline for when you would provide your objections to the state's exhibits. Mindful that this will take place on September 3 and that we have pretrial set for September 26th. And if we need to have a hearing with regard to those objections, my thoughts would be to give you 2 weeks until the 17th to lodge your objections. And those would need to be provided in writing by the 17th. So that if there are objections and if we need to have a hearing on them, that hearing can be held when we have our pretrial on the 26th. That would give the state ample opportunity to prepare for any of the objections that you have.
Forgive me, and thank you for your patience, everyone. So on September 3rd, I will be viewing the digital and physical evidence here in the courtroom.
Correct.
And then later that afternoon, I will be meeting with the state and my investigator.
If they don't meet with you prior to that date. The deadline for the state's investigator, your investigator and yourself to meet to review the digital evidence would be no later than the close of business on September 3. I've outlined for when I would like it done, but if the state wants to meet you in advance of that date, they can do so.
Yes, please. If I may ask, please, what is your name, sir?
William J.
Could you spell your last name, please?
J-A-Y. Don't get fast.
And what is your affiliation with the state?
I'm a homicide unit chief.
Yes, please. And I am okay if you would like to meet prior, so less time is consumed on the day of our meeting, supposedly on the 3rd.
So I assume you have availability. Should I meet with Mr. Lane to discuss his availability so we can get out there this month?
Yes.
Then you can do that. And like I said, Mr. J, if you could file that notice, just identifying when, that would be most appreciative. So ma'am, understanding where we are with the viewing, what is September 17th for the deadline for your objections acceptable to you?
Yes, and if I may please raise the point that I have a motion here in regards to, well, I'm in the process of working on it for the laptop. I do not have my discovery as of yet, and I do not have the laptop as of yet. I do not know what hiccups may be involved. There's a lot of hiccups with the jail already. So I'm trying to figure out when and where I'll be able to view anything. So there's a rate restriction also that is being put on the laptop usage from 8 to 4. I'm unable to utilize my time to the full extent. Also, I have a motion here to receive my hard copy evidence because when the laptops are in quotes, the laptop is in quotes, closed for the day at 4 p.m., I can therefore pick up using the hard copy evidence.
I haven't had the opportunity to review the motions that you're speaking of, neither has the state. We'll address them today. I don't have a problem doing that. I'm just not going to do it right this second because I haven't had the opportunity to review them yet.
Yes, and I'm just explaining myself in the meantime, please, so you're aware of what I had already thought of and am trying to ease the pain of everyone with me trying to figure out how to do everything and when and do it appropriately. But I just wanted you to know that by bringing that topic up, I have that to also be looked over.
Okay.
Thank you. 9/17, if that has to be changed, am I okay to do that?
I'm trying to set deadlines now, ma'am. And that would give you 2 weeks to review the physical evidence. You'll be provided the digital evidence, it seems, in advance of that September 3rd deadline. And that may give you more than 2 weeks to review and lodge any objections.
This is just for the evidence?
Correct. This is only addressing any objections to the evidence that the state seeks to admit.
The digital discovery, is any of that included in that?
Yes.
Okay. I am very weary to make these type of deadlines.
Well, we're setting them today,
I understand. So the 3rd is a what day? Thursday?
Tuesday. So the 17th would be 2 weeks later, Tuesday the 17th.
And that is me coming with my objection.
That would be you filing your objections in writing with the court. And to the extent we would need to have a hearing on those objections, we would have them when the pretrial or trial case management conference is set at 9 a.m. the following Thursday, the 26th of September.
I'm sorry, what is on the 26th?
That's when we're having our pretrial or trial case management to address any last minute issues regarding trial.
Forgive me. So today being August 5th, I'm supposed to expeditiously complete my case that in every way, shape, and form by September 26th in order to go to trial for October 7th.
The dates are what the dates are. September 26th is the trial case management date, and October 7th is the trial date.
So by me not even seeing my discovery yet 2 days, and only being restricted to a laptop from 8 to 4 and not having my hard copy evidence.
You have 62 days to prepare for trial, not including today. And you're going to get your discovery today.
Wow. So in over 4 years, it comes down to me representing myself in 62 days?
I'm not going to answer that question.
Am I supposed?
What now we're addressing, ma'am, is September 17th.
Right.
The deadline, which is 2 weeks after having the physical view of any of the physical evidence. It sounds like Mr. J is going to try to meet with you pretty promptly regarding the digital evidence. So you'll have plenty of time to review that in 2 weeks at a minimum, or 2 weeks at most rather, to lodge any objections to the physical evidence.
I understand. I just don't understand how to file objections.
I cannot answer that for you. That would be me providing you legal advice, which I'm prohibited from doing. All I can tell you is that if you have objections to any of the exhibits that the state may seek to move into evidence, you will have to lodge those objections by the close of business on September 17th. And those objections will have to be in writing. If we have to have a hearing on those objections, that hearing will be held on September 26th.
Okay, and if I may ask, are these being delegated or I'm being incorporated in this in order for me to be able to say yay or nay?
I don't know what that means. What do you mean delegated?
Are you delegating to me as you've delegated everything else in regards to taking my counsel and all of your orders?
You are representing yourself for the reasons that the court identified in its 16-page order. It is your responsibility, as you are representing yourself and proceeding pro se, to comply with the court's orders and deadlines. So if you have objections to any of the exhibits that the state may be seeking to offer into evidence, be it digital or physical, based on your review of those, the deadline to submit those in writing would be on September 17th.
Okay, so you're making statements, so I don't have any say in it.
I've asked you what your thoughts would be as to when. You've never provided me in a disagreement with regard to that date as of yet. You've asked questions about your motions that I haven't seen yet, your desire to have hard copies, which we addressed at the last hearing, but I'll be glad to address it again today. You have yet to tell me that that date's unacceptable for you, and if so, why?
I wouldn't necessarily say unacceptable. I'm just uncomfortable with agreeing to a date when I am pro se and have never been pro se before and do not know what I'm doing. So I just want to make sure that I do it correctly and have an understanding also, if you are proposing that I go to trial within 62 days, that I know what I'm going into and what I may expect. So I didn't know if this would just be easier on everyone else, if they just delegated the dates and gave me a printed copy with your order and whatever information you have. I don't know. I don't know either if you all are just proposing that because I'm incarcerated, just the dates are what you tell me. I don't know what I'm doing. I do not know what I'm doing. So I'm trying to learn as I go, which is why I'm grateful for everyone's patience. But at the same time though, for me to accept this date and then not be able to meet it, what happens when that happens, if it should happen?
I can't answer that question. Again, that would be me providing you legal advice as to what to do if something happens. I simply cannot answer that question. I'm not allowed to.
Okay. Well, I'm with the court, so whatever it is that you all are trying to do in order to expedite this even more than what it's being expedited, I'm guessing I agree with September 17th.
Okay, all right. Now, ma'am, I believe that takes care of all of the deadlines with regard to the state's exhibits. Now I want to address deadlines for any exhibits or witnesses that you may be seeking. I am mindful that you will be receiving the discovery today and that you have not had the opportunity to review some of the items that may be in the discovery. So how much time would you like to provide to the court the list of exhibits that you may be seeking to enter and the list of witnesses that you may be seeking to have testified in a defense should you choose to put one on?
Please understand that I do not have access to a normal phone. I don't have access to a normal phone at normal hours. So I am trying to overcome the hurdle of trying to, number one, locate any of my witnesses, and then also try to communicate with them on a payphone only telephone call that I do not have regular access to, and that are limited to only 15 minutes that I have to share with 62 other inmates. That is a hurdle, please, that I need for you to please take into consideration. in order for me to be able to try to determine my witnesses, to determine any expert witnesses. May I ask, please, does the laptop have internet access?
I'm unaware. I'm unaware if it does.
To view any documents?
I'm unaware. I can't answer the question that I don't have an answer to. I'm unaware if it has internet access.
Whom is it that I need to speak to in order for this?
We may be able to inquire of the jail representative who is appearing for the hearing this morning, and if not, the captain may be able to provide that information, but I do not know if it has internet access.
May I ask your contact names from the jail?
Give us 1 second.
Please, and also because of the court's error of sending my information that you're referencing to the incorrect address, could you please provide me a copy of that also?
What is it that you're asking? Which, the protocol, ma'am? That was what was most recently sent.
I don't know. Whatever it is, the last thing that I received from you and the court was the hand delivery of the order regarding
Sure.
USB.
I have a copy that Madam Clerk's already printed out of the protocol. We will have the deputy hand deliver that to you right after. Did what I did? No. Oh, I sent it to Anita. That's why. Give me a second. I'll have Madam Clerk print that out for you right now, ma'am.
Thank you.
So, understanding that as of right now, you do not have hard copies. You'll be provided digital copies. And to review all this evidence, ma'am, when in time do you feel comfortable in providing the court and the state the list of your witnesses and your exhibits that you may be seeking to introduce?
I'm going to go with to be determined because I just explained also, please, that I do not have access to a regular phone. I need to locate anyone. I need to do research. I don't know if I have internet access to anyone. I don't have a phone book. There's no way that I know how to do any of this without essentials and fundamental equipment in order for me to be able to provide you with those answers. I cannot promise anything because I do not know how I will be able to do any of that at this moment. I would like please to propose your understanding of a meeting that I would like to have with the captain so I can see if I can have access to a regular phone, if I can have access to an internet. Right now I have a tablet that is used for text messaging and movies and the law library that I utilize. I don't have access to the phone. I don't have access to the internet.
You can certainly have those conversations with the jail representatives. But ma'am, we were on notice today to address those deadlines, and I cannot set a to be determined deadline at this time. I understand that there's been some delays with regard to the discovery. As I told you at the last hearing, we're moving as expeditiously as possible to get you that, and it took some time for that process to be created. That process is going to start today. Mr. Lane's here. Representative from the Orange County Jail will be here. That handoff will take place. You'll have access to that laptop with all the information today.
If the defendant's not going to make a suggestion, make a state.
Sure.
My suggestion would be to give her 14 days after the point that the specific evidence identified by the state to be used at trial is provided to her. So, for example, the physical evidence, which we plan on giving her the list of those physical items well in advance of September 3rd. That will just be the date that she can actually see them. But my suggestion for those physical evidence items would be September 17th, and then 14 or 15 days after whichever day we get the specific list of digital evidence items to her, would be our suggestion.
Okay. Ma'am, are you amenable to that? That would 14 days after you've had the opportunity to review the digital evidence and 14 days after you've reviewed the physical evidence to provide your exhibit lists?
I don't feel comfortable with any of this. I don't have the same opportunities as the state or any attorneys prior. So I feel that you all are pressuring me and forcing me into these things which I may not be able to meet or exceed.
Can I add that obviously either side, if there's good cause for why a deadline wasn't met, if something comes up, then we're not prohibited either side from complying with the rules of discovery afterwards. But there would just need to be a cause shown at that point.
Do you understand that, ma'am?
I do.
That I'm setting these dates for now, and if either party can establish good cause why these dates should be moved.
Well, I missed some of it because I was trying to help Allie get a rental car in Miami. But I mean, her issue with the electronic discovery is that I don't think that she has access to the laptop 24/7, right?
She does
That's
not.
That's why she wanted a paper discovery, which she has a point. I mean, she's got to be able to prepare. I mean, like, yes, she's made her bed. Yes, she has to lie in it at this point. But notwithstanding that, if she is incarcerated, which she is, and she should have the right to prepare for trial. And if she's got limited access to look at shit on a flash drive, they need to print the shit out for her. I think that's an issue that could really be a real issue for the appellate court. If she's, because I mean, if she comes back and says, okay, well, I can only be on the laptop for 3 hours a day, like, how am I supposed to prepare for the trial? It's like, yeah, I realize I've shit canned a bunch of lawyers and your judge got sick of it, or your honor got sick of it. Fine. I'm going to do this, but I have to be able to prepare. I have to have the discovery. You've got to get it to me. So, I mean, she's got a decent point there, because even like I don't know if that's the state or the judge that's saying, with the discovery deadlines, if she gives a valid reason as to why she couldn't get it done, well, she's giving it to him. I can only be on the computer X amount of hours per day. And that's the only form that you've given me the discovery. So how am I supposed to know? I've got to prepare for the trial. I mean, I think that it's within the judge's discretion to hammer her on I'm after this many attorneys, like, you've run your course. I'm not going to do that anymore. However, he's got to give her discovery. She's got to be able to review her discovery in her cell. Like, she's just got to be able to do that, because otherwise it's a trial by ambush. I don't know.
Yes, and that is why I'm trying to make everyone aware prior to all of this, to understand my circumstances by being incarcerated and not having access to a phone, not having access to the internet, and not having access to many more other, like I said, basics, fundamental basics, which is why I'm making you all aware now, so you are aware that when the time comes, should it, why for good cause, I'm stating my good causes now, if not, there are additional at that time.
Ma'am, as of right now, the court is inclined to agree with the state's suggestion that 14 days after viewing the digital evidence, which will take place no later than September 3rd, sounds like it'll take place way in advance of that, you are to provide in writing your list of exhibits that you want to attempt to move into evidence. 14 days after viewing the physical evidence on September 3rd, you are to provide in writing the list of any exhibits that may be physical that you intend to enter into evidence. Those dates can be extended for good cause that may be shown. State, would you like the opportunity to review those exhibits similar to an evidence viewing that we're having with Ms. Boone reviewing the state's exhibits? Would you like a similar opportunity to review any of her exhibits?
If the defense has any physical evidence to place in evidence, I can make those arrangements.
How is she going to have any physical evidence? She's in jail. Like what physical evidence? She's not going to have any physical evidence. So, like, the volume, like, it's not going to be voluminous with the electronic or the video evidence. It's like, it's the videos. So, like, I don't think there's going to be a massive amount of evidence that she's going to have to contend with. Like, I'm sure they'll want to bring the suitcase in. That'll be physical evidence. That's the murder weapon, right? Death by suitcase.
Right. Mm-hmm.
But in terms of what else, I don't know. I mean, they're going to bring in the receipt for the wine. They bought 2 bottles of wine that day. And they'll probably bring in the wine bottles that were empty, found in the garbage. I don't know.
Any sort of like, I mean, I guess it's not, but like a schematic of her, the apartment where everyone,
the layout. Yeah, the layout for sure.
Okay, all right. I will set a deadline for the review of September 26th.
Thank you.
Is the review that you're speaking of, please, for my exhibits and witness list?
That is correct. I would also propose a similar date of September 17th for any of the witness lists for the defense. And Mr. J, would you be in a position by the 1st of September to provide any witness lists for the state?
She should have the witness list in the discovery that's being provided. As far as the order and the list of witnesses that we're going to call at trial, we will get in that ahead of 9/3.
Okay, all right. So the deadline for the state's production of the witness list will be September 3, no later than, and September 17th for Ms. Boone. Ma'am, similar to the objections to any discovery, that'll have to be in writing as to who it is that you may be calling as a defense witness. And you'll have to provide that to the court in writing by September 17th.
Yes, and if I may ask, please, what you're typing, is that for an order or for today's proceedings?
It is for an order, which you will be given a copy of. It may not be able to be hand delivered to you, ma'am, because I'm gonna have to move some stuff around based on my scratch notes here, but at a minimum, it would be mailed to the your proper address due to that clerical error. That will not be an issue.
Wonderful, thank you.
Okay, I think that addresses all the issues with regard to production and hearings on any objections. Anything else from the state that you believe we need to address from a scheduling concept?
We're good with the scheduling concepts. Thank you, Judge.
Thank you. Ma'am, do you have any questions with regard to the scheduling concepts or deadlines that we've addressed this morning?
You know she does.
Other than what I have made known to the court, I do not.
Wow.
Okay. Bruce, can you see if Mr. Sergeant Casey's here? He is here. All right, very good. Sir, could you come on up, please? Madam Clerk's going to go ahead and swear you in. You can stay to the podium, sir. No, just the podium, Sergeant.
Oh, sorry.
If you could raise your right hand, Madam Clerk's going to go ahead and swear you in. All right, sir, good morning. Could you state your name for the record?
Sergeant Casey.
And what's your position at the Orange County Jail?
Sergeant.
And what are your duties and responsibilities, sir?
I'm over transportation, downtown port holding, BRC courts, medical security, and the juvenile assessment center.
Okay. Are you aware of the protocol that Captain DiGiovanni created with regard to Ms. Boone's use of the laptop?
I am.
Okay, all right. Have you had the opportunity to review that protocol?
I am.
Okay. Mr. Lane, can you come on up here, please, sir? Sir, good morning. Could you raise your right hand? Madam Clerk's going to swear you in.
You swear or affirm the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, sir, good morning. Could you state your name for the record for me?
Willie Lane.
And what's your affiliation with?
I've seen a couple comments. Bonnie had said Sarah's playing the system. Like, I'm curious to the people that think that she's playing the system, to what end? Like, it's one thing to say that she's playing the system, but for what purpose? Like, extending, like delaying trial. I mean, she's still, it would be one thing if she was out on custody or out of custody and walking around. Like, that argument holds water. You know, people are trying to, like, my clients all the time when they're out on bond are like, shit, delay that shit as long as possible. I'm not trying to go to prison yet, you know, but when she's in custody, I just don't see, like, I'm curious, and I'm not being argumentative about it. I'm just curious as to what y'all think, like, why, what advantage she has in delaying. Like, I mean, she's in custody, in jail. I mean, the only difference is she'll be sent to a prison. I don't know. I don't know.
That's why I asked you that before, because I'd always thought that jail was better than prison, but now I'm learning that it's sometimes
it's really not. Yeah,
it's not.
It's really, I mean, you just like the amount of programs that they have, and like prisons are just more modern. You know, they're going to have way more programs available to the inmates in terms of educational stuff, better libraries, just like, you know, everything in prison is going to be bigger and better. I mean, it's still prison. Don't get me wrong. You're still in the joint. It still sucks. But
which one is easier to sneak in a cell phone so I can make TikToks? Whichever that one is, that's the one
I
I
would
wanna
say
go to.
prison, probably.
Is that the
Probably
TikToks?
prison.
Yeah, they're prison. I think you're right.
Yeah, probably.
Have you guys ever seen those? They're wild.
The TikTok videos?
Yeah,
Yeah,
like these dudes are in jail and they're just making TikToks.
I mean, how many do they
prison.
get out before they toss their cells? I mean, do they get like two or
I don't
three?
follow any of them, so sometimes they come up on my page and they're just like, it's that's a good question. I don't know.
I've seen one where they were making the toilet wine.
Yes, yes.
Yeah, I mean, man, that's something.
With Prison Break Investigations.
I'm the owner and chief investigator.
All right, sir. Last time I saw you, I had tasked you with digitizing 2 bankers' boxes of information. And you said that you would endeavor to accomplish that task by today, understanding that you were out of town for your son's wedding. I hope you had a great time. Were you able to fulfill that task, sir?
Yes, sir.
Okay. How many jump drives or drives do you have?
Of the digitized information, there's one of those. This drive here is a copy of all digital discovery that I have in my possession from Ms. Boone for the court's needs if they wish to facilitate that through the, figure it'd be easier to facilitate it now through the jail than me trying to bring it in myself.
That's exactly my thought. So you've shown to me, sir, a small thumb-sized USB jump drive. That USB jump drive is the information that was contained in the 2 bankers boxes, correct? And the other jump drive that was the larger of the 2, that jump drive is any digital information that you've had previously by virtue of being the investigator.
Yes, sir.
Okay, all right. The record's going to reflect that information is going to be hand-delivered by Mr. Lane to Sergeant Casey. So Sergeant Casey, if you could please take custody of those 2 thumb drives. And I'm going to ask you, sir, to comply with the terms of the protocol, to have those added to the laptop. It'd be available for Ms. Boone's use today once she's returned to the Orange County Jail. Do you have any questions for Mr. Casey?
No, Your Honor.
Okay, sir. Thank you very much. If you can proceed with that task, I appreciate you. Thank you. Mr. Lane, you took custody with you, sir, as well. Well, before you leave, Sergeant Casey, state, do you have any questions for him?
No, Your Honor.
All right, ma'am, do you have any questions for Sergeant Casey regarding his compliance with the protocols provided to be by the captain of the jail?
Mr. Casey, could you please make note to Captain Giovanni that if she has time at some point, as soon as possible, to please sit down with me for about a half an hour to go over quite a few things that I need to have resolved.
I'll look for her.
Please, in regards to the laptop.
Okay.
Thank you.
Thank you very much, sir. Mr. Lane, when we were last here, you also had 2 bankers boxes. Did you bring those back with you, sir? Okay, could you bring those back up?
There it
You see,
is.
it looks like the original exhibit tags are still on the top of those.
There's the shit for her.
Mr. Lane, did you complete and copy everything that was in both of those boxes?
Yes, sir.
Okay, I'm gonna have Madam Clerk take possession of what was pre-marked as A and B for the purposes of the June 28th hearing, and we'll hold those into evidence. Do you have any questions, Mr. J, for the investigator with regard to his task?
No, Your Honor. Thank you.
All right, ma'am, do you have any questions with regard to your investigator regarding his completion of the digitization process?
And my only question is, Mr. Lane, do you know when you would be coming to meet with me at the jail?
It's going to be my intent to try to get out there at the end of the week or beginning of next week.
Whoa, what happened?
Blackout.
Sir, I don't feel comfortable signing your invoice. I think Ms. Boone would have to sign it.
Okay, that's fine.
Okay.
Is it okay if I?
Hand it to the deputy. Deputy will have her sign it, and then you can take it. Mr. Lake, is that acceptable, sir? Counselor, you're muted.
Yes, that would be acceptable, yeah, if Mr. Lane, and Your Honor, in light of this, maybe it might be more appropriate for the court to go up to 10,000 for the investigator, because it sounds like he's already done a lot of work. So it might make more sense instead of having to come back later.
Would that change the original, the 5,500, or just we would increasing 5,000 to 10,000?
5,000 to 10,000, I think would make sense, Your Honor, just because it sounds like that we may, based on what's already been done, and Mr. Lane may have more to say about that, but based on what he's already done, I suspect he's probably used a large chunk of that 5,000 just doing this one task.
One thing I would like to add, Your Honor.
Yes, sir.
In lieu of having to come back and file another motion, is if JAC would agree to travel expenses since I'm out of county. If not, I can get that in some type of form of a writing and get it to you or to the JAC if that's acceptable.
Mr. Lake?
Your Honor, we'd have no problem with the court authorizing, say, $1,000 for travel expenses as well.
All right, fine. So we'll increase it from 5,000 to 10,000 for investigative costs, and for travel-related expenses, 500 to 1,000. Mr. Lake, are you going to need an order for the court file with regard to those?
We would, Your Honor.
Okay, could you submit that?
Yes, Your Honor, we will prepare the order and submit it.
All right, very good. Just send it to Ms. Barrios, who I believe you have her contact information.
Yes, Your Honor.
All right, very good. Thank you, sir. Mr. Lake, thank you so much, sir.
Yes, sir.
All right.
Judge Payne,
Yes, ma'am.
what is his name, please?
That's Christian Lake. He is an attorney associated with the JAC, the Judicial Administrative Commission, regarding costs for indigent defendants. All right, state from a scheduling perspective or the protocol, which I know I filed a notice of filing of, I'm sure you've had the opportunity to review it. Anything else we need to address from that?
We're good on scheduling, Your Honor.
Okay, thank you. Ma'am, anything else we need to address regarding scheduling or the protocol other than what you've already addressed this morning?
Yeah, Shiraz. I think that's
Will
it.
my investigator be present at anything for and with me?
I can't speak to for or anything, but based on what we discussed today, your investigator will be there for the digital review, which will take place no later than September 3rd.
Okay, yes, I would like to have some type of witness from
He will be
my
there.
side also.
He will be there. Mr. J is going to be recording the conversation as he identified previously.
Thank you.
Now, ma'am, you made reference to some motions that you may have brought with you this morning.
Yes, please.
All right, if you could hand those to the deputy.
Zoom in on her notepad. I
Also,
want to see
please
it.
have the
She's
deputies
drawing
not
stick
already
figures
done
of all the
so.
people
I
in
printed
court
out a copy of the
in a
July
nice little
24th.
house with the sun.
Can you guys hear JOK when I have the thing? I have a hard time hearing him, but I'm just hoping you guys can hear him. Like I can't hear him like I normally hear him because I got the booster on because the sound sucks on this.
I was just saying they got to zoom in on our notepad because it's just stick figures of all the people in court. A little house with a chimney and smoke, a sun.
Oh, love it.
2024 protocol regarding your use of the laptop at the jail. And I'm going to ask the courtroom deputy to please hand deliver a copy of that to you. It was mailed to you. It was read to you at the last hearing, but now you have a physical copy of it, ma'am, to the extent one was not already provided to you.
Oh, yes, I have not received this yet.
Okay.
And then also there was another printout that she was going to provide me with, which I believe was a memorandum for today's date.
I haven't, is she being who, the captain?
No, I'm not sure her name.
Oh, Madam Clerk, no, the only thing she's printed out for you right now, ma'am, is that protocol. I'm going to be finalizing the order. And like I said, I may be able to finish it before we're done with the hearing, and I'll hand deliver it to you. If I cannot, it'll be mailed to you.
Yes, I understand. It was regards to another document proposing the dates for today's hearing. And I guess it was some type of notice. That's what please that she was going to print out to give to me, so I have that.
Okay. Mary.
I did not receive that, nor did I receive this protocol list.
As to everything that was being discussed, can you print out a copy of it? It should be in the court file. All right, ma'am, let me take a moment to review your motions. Give me a moment here.
Thank you.
You could probably bloopity bloop. He's got to read fucking Sarah's hieroglyphic, her emotions. Actually, her handwriting's not too bad, to be honest. There's a bloop bloop emoji. I didn't know
Bloop,
that.
bloop. Oh, bloop bloops. Oh, let's do the bloop bloops.
Yeah, he's got to review her note. Or
all right, hold on. I'm gonna bloop. Bloop, 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 bloop. See.
Parentheses, submitted to the court by former attorney, parentheses, S, and parentheses, on June 28, 2024, for preparation of trial in her criminal case. Just review those, Counselor, and just let me know when you're ready to address them.
No, he's got to
Your Honor,
review
in
them
regards
too.
to the first motion, we need to notice the sheriff's office, who is in charge of courtroom security. So we're not able to address that today unless they're allowed. I don't know if you're able to contact the person that's in charge of that today. Otherwise, we would need a separate day for that motion.
Okay.
As far as the second motion, it's completely up to the defendant. We have no standing to say anything about it. If she wants to have her documentary discovery in hard copy form, that's between whoever and whoever, but not the state of Florida.
Okay, all right, I appreciate that, sir. Ma'am, with regard to your request for discovery, the hard copy discovery, you've advised me multiple times seeking to use a laptop. I've written correspondence from you asking for a laptop. That laptop is being provided. At the last hearing, you advised that you wanted hard copies. You've also advised me that you live in the female dormitory, you have limited to no privacy, and you have nowhere to store anything. You have a small drawer to keep personal effects, and that's it. There's nowhere, is my understanding, in communications with the captain to place this information. There's nowhere to house it. There's nowhere to store it. You do not have, by your own admission, any place to place it.
Is that your understanding now? Are you asking me?
No, those are just statements that I know that are in the court file that you've made. You've written letters requesting a laptop. That's been provided to you.
I've never.
You have written letters, ma'am, specifically asking for a laptop.
Do you know what the date of that is?
Without me going through all the correspondence. But when we have our hearing on the issue of the your motion for freedom and movement, where I'll notice the sheriff, and we'll try to set that up for this week so that it can be done expeditiously.
Okay.
We can address that at that time. But the jail has advised me they have no place to store this information, these hard copies. You've advised me you have no privacy and nowhere to place them. So I'm not saying no, but I don't know how I can facilitate this for you when you do not have a place to store it. The jail does not have a place to store it.
We have an entire property department for all of the inmates on the entire compound. I've been given permission also.
Just for the record, I'm pretty sure that what she's drawing on her little notepad is this, dude. It's definitely this. Boop. Jackie Tree, the great Jackie Treehorn. Pretty sure that's what it is. Pretty sure. Jackie Treehorn. All right. Sorry. That was just an aside.
Oh, Bob just broke the whole stream.
Oh, hold on.
Did you forget that it didn't?
Hold on. How do I put it up?
Help me understand, please, for future reference, so I know how to approach. By my statements that I have made to you, questions were not asked in order to come to the conclusion that you are coming to that I did not want my hard copy. I was never formally asked by you to see if I wanted my hard copy discovery. I would believe it was the court's understanding, the judge's understanding, that it should automatically be allowed to give to me. My understanding, and trying to explain to you also, so you have an understanding, is my limited restricted access to the laptop is from 8 to 4. I, with 62 days left in order to defend myself in preparation for trial, would like to close that laptop at 4 p.m. and then pick up the discovery hard copy in the 2 boxes that I have. I haven't spoken to the captain yet. I just now received the protocol for the laptop. I know that you had mentioned it to me the last time we met with one another. So I'm confused how everyone is confused by me coming to the court with solutions and ideas and suggestions, but are being misinterpreted and misconstrued, like my letters from my attorneys, and you're coming to the wrong conclusion.
I'm not coming to any conclusion. The process was created, and I'm just reciting what you've said to me at prior hearings, ma'am. That's all I'm doing. You've told me you have limited space. You've told me that you have no privacy, and that you have a small drawer for personal effects. This is the first time I've heard anything about you having a locker or some kind of bag or property bag that you now have access to. That wasn't addressed at our last hearing. This is the first time I'm hearing about it. So I'm not drawing any improper conclusions, as I identified for you with the process. The jail created this process. It was something that they put together. And as I told you, we worked diligently to move forward, to get with the jail to have this done. There's no nefariousness here. There's no undermining. There's nothing along those lines. I want you to have this information. And as I addressed at the last hearing, I could not copy it. I can't look at it. I can't look at what's in those 2 bankers boxes. Ms. Berrios cannot. No one associated with my office can look at it. We had to use your investigator to do that. And what the jail has advised me is that they were not in a position to take both those bankers boxes because of space and potential hazards. Now, if something has changed and the captain advises me that you can have those documents, I don't have a problem with you having them. But what I've been advised, as identified in that protocol, is to how and when you can have access to the information. And unfortunately, it wasn't in physical form, it was in digital form. And that was the process that the jail created. They are aware it's 2 bankers boxes. They're aware of what the information is. Everything has been out in the open to address your concerns and how to facilitate getting this information to you. No one's withholding anything. No one's trying to hide the ball.
My opinion differs. I was never asked anything, just like my letters to you prior to you forfeiting my right to counsel. I was never asked anything in order for you to have a better understanding.
Ma'am, I'm not going to revisit that.
I am not, you never asked me in regards to the hard copy.
Hang on, yes.
How quickly can we have an evidentiary hearing with the captain or whomever we need?
My understanding is she's on vacation this week. Okay. So, which is why Sergeant Casey was here, because Captain DiGiovanni is on vacation. And I cannot recall off the top of my head when she's set to return. She's set to return on the 12th.
So if the document, what would be the process? Because it's marked, tagged, and in evidence, so there would need to be a motion to get it released from evidence.
I mean, I would entertain an or tennis motion to have it released from evidence. The concern as, and Mr. J, this is the first time I had the opportunity to discuss this case with you. I know I've been dealing with Mr. Cacciatore. We had a hearing, and I'm sure you're versed on this, but let me just kind of bring you up to speed. We had a hearing in June, and at that point in time, I forfeited Ms. Boone's right to an attorney based on her conduct and alternatively a waiver. And I'm sure you've read it. Thereafter, the court endeavored to figure out how to get those 2 bankers boxes that Ms. Cashman had provided to the court at that hearing in Ms. Boone's possession. It took time for the jail to come up with a policy and a procedure for that to happen. I was advised by the captain that they could not take custody or possession of those 2 bankers boxes because of A, storage, and B, because of the hazard. Now, if the jail is in a position to revise that by virtue of Ms. Boone identifying a property bag or something that may be available for her use, I am 100% on board. If the jail says, yeah, we can facilitate and make that happen, her getting that information. I'm just traveling with what I've been provided and the protocol that was provided to me that's been filed in the court file was not inclusive of providing her hard copies.
I understand. I'm just trying to find a solution. So
same.
If she moves or tennis to release those 2 exhibits to her investigator, then perhaps he can try and get them released to her. And if he cannot, then it sounds like on the 12th, we can revisit this when the captain's back.
I think, I don't know if she returns on the 12th or that's when her vacation ends. It's a Monday, so I'm assuming she'll be back, but I don't want to make any affirmative statements on that. I don't have a problem. Mr. Lane's had this discovery. I don't have a problem with him taking custody of it again. And if he's able to deliver it to the jail and they allow it to be released to Ms. Boone, I don't have a problem with that. I have no problem with it. I'm just traveling on what the jail has advised the court in the creation of this process.
So if she wants to ori tennis, which means oral motion, move to release those two exhibits, the state has no objection. And it sounds like if Mr. Lane can't get them to her, we'll be able to revisit this in the near time future.
Yes.
Just so that she's advised. So I don't want to ask her, but perhaps the court can ask her.
Sure.
If that's what she wants.
Ma'am, the state has recommended a position for in an attempt to get you these hard copies. Is that something that you would like the court to, would you like to follow with the state's suggestion and ask of that of the court orally this morning?
I'm not understanding what it is that he's trying to do. May I please propose that the hard copies go to Mr. Lane, and then once I have permission by the captain and whomever, he can release them to me?
Granted.
No objection to her motion.
Okay. Mr. Lane, thank you for staying, sir. I appreciate you. If you could come back up here, sir, and take custody of both of those banker's boxes. I will have Ms. Barrios coordinate a hearing for the 13th at 8:45. Why not? We cannot do it the 13th because it's pre-trial. You're correct. We will have a hearing on August 14th, if necessary, on Wednesday, August 14th at 1:30, if we need to address the jail's position in taking hard copies if Mr. Lane's unable to have it delivered. And Mr. Lane, you had advised earlier when Ms. Boone had inquired of you as to when you might be able to go visit her. You said the end of this week or by next week.
Jay, I'm not going to lie. I was really hoping that his pants were going to split when he was bending down to put that box. I was praying for it to split. It would have been an unbelievable moment, but alas, it did not happen.
When you go to visit her by the end of this week or next week, bring that with you and see if the jail would be in a position to take it. If they are, I'm going to ask you to file a similar notice, sir, that information was provided to the jail on what date and to whom. Okay. All right. Thank you.
Your Honor?
Yes, ma'am.
What would the hearing be for on the 14th then, for the jail taking?
The hearing on the 14th, ma'am, would be if Mr. Lane is unable to have the jail take physical custody of those two boxes for your review outside of the laptop, we would have a hearing to address what, if any, protocols the jail may be able to utilize in you having those documents. It may not be necessary. We're going to go ahead and set it if we need it. If we don't need it, we will not have a hearing.
Thank you. And then so there would not be needing to be made an updated evidence control sheet right now. It has been passed to Mr. Lane.
As of right now, the court minutes are going to reflect that what was pre-marked as A and B from the June 28th hearing is being provided to Mr. Lane.
Thank you.
Okay. With regard to your reasonable freedom motion, I'm going to set that for this Friday. Is the state available at 8:45 on Friday?
No, I looked at that date, please.
Oh, that is the 9th, ma'am.
We're available, Your Honor.
Okay, Ms. Barrios will coordinate with a representative from the Orange County Jail to address the reasonable freedom motion. Ma'am, I'm going to hand file both of these motions with Madam Clerk, okay?
Thank you.
All right. Is there anything else we need to address this morning, State?
Not from the state.
Anything else we need to address, Ms. Boone?
Please bear with me, just please, one moment.
Uh-huh.
What was the conclusion for the sensitive issues of having the media incorporated in the courtroom?
I need to research that matter a little bit further before I can make an order that would prohibit media access.
Do you know what your deadline may be or estimated?
It'll be well before the 3rd. That deadline is set for September 3rd at 9 a.m. when we'll have that viewing. I will endeavor to get that done as quickly as possible. Ma'am, you also had asked for a list of the persons that Captain DiGiovanni had provided. The names of the persons at the jail regarding the laptop protocol is Captain Giovanni, Donald Casey, who was here this morning, Stephanie DeJesus, Sonia Robinson, Courtney Battle, and Malik Muhammad.
Thank you for that. Would you be able to provide me with a hard copy?
I will put that in the order that'll be mailed to you, ma'am.
Wonderful, thank you.
Okay.
If I may, I don't know if I'm allowed to address the state directly.
Yeah, you're representing yourself, absolutely.
How do I go about getting a copy of my phone or utilizing my phone? Is that something that can be brought to the courtroom and during the evidentiary, the physical evidence, that I might be able to utilize that?
So my understanding is there was an imaging done on your phone with software called Cellbrite, and that is part of the digital discovery that has been provided to you. If you are talking about the physical device being re-examined by your own expert, then you would need to find and retain your own expert to do that without giving you legal advice or suggesting that he is the person you hire. I know that defense attorneys in this area hire somebody named Richard Connor, Connor, and then that will be between you and the JAC and him, whether or not he wishes to work for you and at what rate, so on and so forth. And then that examination would be done by him.
Don't pick up the phone, Richard.
President would want to be present.
Yes, I have reviewed, I believe, 2 or 3 different thumb drives were given to me at one point, where I researched all of them extensively, also included with Mr. Lane, and it is nothing of use. It's primarily cookies and history and so forth. So that's why I don't understand who it is, the legal expert that can give me a mere download of my entire phone in regards to videos and pictures and contacts. I could probably supply a witness list sooner than later if I were to have accessibility to my phone in regards to my contacts. That's why I didn't know if it would be allowed to have my phone physically here in the presence of everyone, including law enforcement, to be able to physically look at my phone and go through it and to see what I can extract myself while here in the courtroom before trying to figure out how to locate and contact an expert to download all of that to receive.
So all that information should have been downloaded, and I'm not sure what has been provided to you, but we will be double checking that.
It has not been provided.
Yeah, your contact information, all the videos and photographs, everything on your phone should have been downloaded. And what you may have reviewed is just a PDF file called the timeline. But there is additional data there, and we will make sure you have that. And then when it comes time to our digital evidence deadline, which I hope to exceed well before 9/3, we will be identifying which portions of it is of your phone, if any, that we seek to introduce at trial. So it may be texts from December 2nd, 2019, whatever it is. We will identify those pages, we will identify those files, because obviously your entire phone, however many gigabytes it is not going to just come into evidence. Because like you said, there's so much of it would be not relevant.
Yes, thank you. So you all have already had access to my phone and have researched it fully?
We're not going to talk about our work product. I'm telling you what, based on my experience from other phone examinations is, all that information should be there. And it's typically presented in 2 different fashions. One is a large PDF, typically hundreds or thousands of pages, depending on how much you use your phone every day. And then there's a separate big digital image file that is read with what's called a UFED reader. And then that is where you can go in and look at everything.
Yes, sir, thank you. I've not seen any of that.
We are going to make sure that that is taken care of.
And that, just as clarification from the court perspective, is that something that would have been provided in discovery to prior counsels?
Yes.
Okay, then ma'am, as Ms. Cashman identified, she had everything. It's already been digitized for you. And to the extent you're able to have the hard copies, it'll be provided to you. So you'll have access to all that information today when you return to the jail.
Yes, thank you. None of it was gone over in any way, shape, or form with Ms. Cashman or any prior. So this would be a milestone, an epic milestone for me to be able to finally do that. So now if I don't have what I need or I'm looking for, how do I go about, I know you all can't tell me because of legal matters, but do I need to write a motion? I don't know what I need to do.
All I better say is they better have her on a mic for trial. This bullshit with no mic is crazy.
In order to finally get a copy mirror download of my phone. If it could be brought to for physical, with the other physical.
So again, that is going to be something that requires an expert. And then if you get a defense expert, and the JAC pays for it, then we make arrangements to meet with that expert. That expert will have the opportunity to image your entire phone just as we did, and you all can work with that image. And you're going to be, if you don't already, on those thumb drives that Mr. Lane has, if you don't already have the full extraction and not just the PDF timeline of your phone, you're going to make sure that that is provided.
Okay, so that is not able to be included in the other physical evidence that you all are supplying?
No, what I'm saying is there's two different ways that I see phone extractions. One is the PDF, which is what I think you're referring to as the timeline of this communication, so on and so forth. And then there is the actual ginormous file that is read with a UFED program, and all that should be provided to you. Hopefully your laptop can use it. It does take some specifications on the computer to open it. In fact, we're addressing those issues at our office with our own computers. And if it doesn't work, we will cross those bridges as we get there. And I've worked with Mr. Lane before, just let him know. Mr. Lane knows how to find me. We will work this all out and get what you need.
Absolutely, yes. I am grateful for your information. Just to clarify, please, during the physical evidence and me viewing that here in the courtroom, am I not able to physically open my phone and search through it?
No, because it needs to be in a Faraday box where radio signals don't come and go, because anytime you turn on your phone, it changes the contents of the phone.
Thank you
You're
very
welcome.
much.
Ma'am, do you have any other questions?
Okay, so everyone is aware that I'm in the process of trying to talk to the captain. And handcuffs. Okay. Your Honor?
Yes, ma'am.
I believe I am okay for right now. You and I do not have a direct way of communication, and I didn't know. Another big hurdle is if the laptop has internet access, where I don't know if emailing or messaging or whatever, however it is that you and I can communicate. Rather than snail mail, I'm writing a letter. I don't know when I write a letter how soon you receive it, because sometimes it's days or weeks that it is uploaded to the clerk's website. Do you have a general time frame of when you actually know of something? Because you already had my address correction, but I don't believe updated.
Well, it's been updated now.
No, I mean on the clerk's website.
I can't speak to what's on the clerk's website. I know for the purposes of my records and getting information to you, that clerical error has been remedied.
Do you have any other suggestions? If I do not have internet, would my only possibility to correspond with you be via mail?
That's my understanding. And you asked when I receive things. I get it as soon as I get it from in the mailbox. So we check the mailbox every day. As soon as I get it, it doesn't go to the clerk, it goes directly to me. And I review it. As you saw with the motions that you made reference to at our last hearing, that you had 5 of them, we set those for hearing immediately. And I intend on continuing to try to do that to facilitate prompt resolution to any concerns or issues or motions that you may have.
Thank you. And if I do have internet access or am able to put on, if it's not already, am I able to correspond with you via email?
You cannot correspond with me directly, but you can have conversations with my judicial assistant to the extent that you do have access to internet. I'll make sure to include her email address and telephone number in the order setting the deadlines that we addressed this morning.
Yes, thank you. And for any, I'm not sure.
She's so fucking exhausting.
As soon as something is scheduled, could you all please make sure that I'm included in the certificate of service or portal or whatever it is I might be attached to in order to receive notices to be properly prepared?
Notices have been set, ma'am. To the extent that there was a clerical issue, that's been remedied, but you have been copied on everything that's been filed with the court, including the JAC's response the notice of the hearing that was set for today and the notice of the filing of the protocol. With that, I will see you all this coming Friday at 8:45 to address the motion regarding reasonable freedom in movement. State, anything else?
No, Your Honor.
All right, we'll see you all Friday. Thank you very much.
Reasonable freedom in movement. What the fuck's that? What's that all about, J-Bo? I don't even know what that is. Never heard of it. I've been practicing a long time. I'd like some reasonable freedom in movement, please. Like maybe it's a motion for her to be able to walk around the jail more. I'd like to be able to go to the law library in the jail, please. They probably have like 6 books, all super outdated. So there you go. I mean, biggest takeaway, she's stuck like Chuck with no attorney of any kind. And it seems like it's staying that way. Like I am not getting any kind of indication this judge is going to allow any kind of further continuances in this matter. This thing's going to trial in October. That's the looks to be the thing. Looks to be the thing. So yeah, there you go.
We had a good showing today. I think we had over 500 people. Thank you so much, everyone, for being here. Publicly Buzzed live tonight for he does Murder Church. For folks who don't know, he watches the Phil Spector trial. If you want to see a young Alan Jackson as a prosecutor, so make sure you check that out.
Yeah, and tonight, no Bill Dorsch. We'll be back next week with Bill. But I think what it's going to be next week is we're hoping to have the documentary filmmaker who is making the Reynaldo Guevara documentary, which is when you guys start hearing the details of that case, it's going to blow.
That's going to be awesome,
dude. It's unbelievable. So, and Bill was instrumental in whistleblowing on that dude. So it's crazy. It's absolutely crazy. So, all right, we doing anything tomorrow or what? Like Thursday, we can do Corey Richins.
There's a hearing with Corey?
There's a Corey Richins. Yeah. My friend hit me up and she said that Corey's going to be up on Thursday. Jay, you will not like the time. It's going to be 3:30 your time, but it's only a hearing, so it shouldn't be too brutal. So it's a hearing on Thursday. It's the stipulated hearing on the motion to DQ the prosecution. That might be interesting. That might be interesting. So
other than that, I'm keeping an eye on Little Woo Day. So we watched some of the hearing yesterday, and the judge suggested that possibly he have to like redo all his testimony. Though they have to. I think they're talking about it today. So I feel like if he testifies, we should probably try to cover that because
all right, we'll keep an eye on that, and if you see that it's going, we'll jump on. We'll be on Jay's channel tomorrow. If we're going with baby Woo, little Woody,
not Woody.
Who happens to me, if you guys don't know anything about YSL trial, happens to be my favorite witness of all time. So like that dude's just worth the price of admission. So if you know nothing about that trial, it's a crazy. It's so damn long that's why Jay and I aren't streaming it daily.
105, Bob. It was day 105 yesterday.
Good God, man. Hard pass. But it's a lot of it's interesting to check in when crazy stuff's going on in that case, and there's always crazy stuff going on in that case, but we try to limit it to the craziest of all the crazy stuff, because otherwise it could get pretty mind-numbing, because like in 100 and whatever days, there's got to be just a lot of really slow court days,
Absolutely.
So, all right, well, this is great. Yeah, as Jay said, thank you all. I think we did hit a peak of 5. If you'd be kind enough on the way out to just make sure you hit that like, subscribe. We always love new subs over here. We're super grateful, and share. That really helps get us out to the ether, and we appreciate it more than you guys know. To our mods, thank you as always for being the most amazing in the business. Thank you, Dizzy. I didn't even know Dizzy had made a bloop emoji, so that's awesome.
Good work. And she updated the because it was a Court TV thing, she updated the overlay. So thank you.
I know I did a bit of a little surprise on Dizzy, and of course, per usual, she dominates at all times, at all things. So, and thank you, Jay, for jumping on. I love you, man. Of course. I hope that you stay cool. Keep you and the fam cool in there tonight, man. You know, it's like that's tough living. But fortunately, at least you have a couple of portable air conditioners. So
yeah, and there's a
probably not
storm
like-
right now, so
Good.
the sun is not out. It's the next couple of days is supposed to be cool, so I think we'll be all right.
Good. And we love you guys. Thank you. Best chat in the
Thank you,
land. Thank
everybody.
you for hanging with us all day. And keep your eyes posted on Twitter and your notifications, Jay, and we'll let you guys know what we'll do tomorrow. Ciao.
Bye.
Bella. Ciao, Bella. We're out of here.
Thank you for joining us, J-Bo Nation. Please give all of yourselves an ovation. No, it won't be real long until next time. Oh, J-Bo Nation, there's no place we'd rather be. J-Bo Nation is the place to 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 be.